Lordship, any date.
Services awaited.
Awaited, Lordship. And the VA, Lordship, bail application.
Otherwise, CD available.
27.
27. Monwar Hussain.
We'll take instruction regarding service.
25, can it be, Lordship?
Of the learning council for the petition also heard Mr. K.K. Parashar, additional payment opportunity to send that a services still limited to the respondent to. In that context, Mr. Parashar, the learned additional TP submitted that he will take instructions in regards to service notice on the respondent. However, it is submitted by Mr. Parashar that his diary has already been received. You want to what to do? Prior vacation.
Prior 24 months. CD is available because of that.
24. Deeply obliged, Lord. Deeply obliged.
My lord, I beg to mention item number 39 of today's daily list.
39.
39, my lord.
Yes.
Yes, bail hearing matter, my lord.
Ah.
My lord, in this matter, my lord, that is co-accused is granted by bail by the coordinate bench, my lord. And earlier occasion, it was listed before the coordinate bench also, my lord.
Oh.
So,
Okay.
let it be listed, my lord, before the coordinate. Court number 16, my lord.
Court number?
16, my lord. Honorable Justice Midul Kumar Kolita, my lord.
But whether he is taking
Yes,
criminal
my lord.
bench?
Bail matter today also he has
Criminal
taken, my lord.
bench.
Yes, that's because I didn't.
Court number 2. At the request made by the counsel for the you're for the petitioner.
Yes, madam.
Petitioner. Okay, Bhushan. The matter may be listed for appropriate bench. Today only or what? Tomorrow? Let it be tomorrow.
Madam, tomorrow or day after tomorrow, any date, my lord.
Day after tomorrow, right? 7. Okay.
My deeply obliged.
May it please your lordship. May it please your lordship. I wish to mention item number 26, my lord. In this case, we have filed one affidavit, my lord, along with our wakalat number for respond number 2, my lord. That may be called for, my lord.
Item number 26.
26.
Otherwise, in 26, CD will.
CD not received. Okay, let him move the
Malad.
additional affidavit. We see.
Okay.
We call for.
May it please the lordship, I beg to mention a listing of one review petition, my lord, any date before
Make a
vacation.
mention before court number 8.
No, your lordship has allowed the.
Whatever you make a mention before court number 8 or before it. We are not taking the mention.
Okay.
May I please, Lordship. Lordship, item number 3, Lordship. Kindly withdraw
Item number?
3, Lordship. I am to withdraw this bail petition.
Huh?
Withdraw.
Withdraw this bail petition.
You want to withdraw this?
Yes, sir.
Your good name?
Islam.
Islam. Withdraw hard Mr. Islam, the learning council for the petition also hard Mr. K. Parashar, the K. Parashar, learning council for the elections, when want to withdraw, dispose. Okay, it will be disposed of on bid.
Maybe please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 14, my lord.
1
My
4.
senior, yes, 1-4.
Yes.
My senior is annual, my lord. So matter will be fixed after vacation.
Yes, Mr. Nawaz, you are for the respond number
I'm
4.
for the respondent number 4, my lord.
With your senior, Mr. Majar Bhuiyan?
Yes, madam.
You are Mr.
Arrive here.
R.I. Bhuiyan. Heard Mr. R.I. Bhuiyan appearing on behalf of Mr. M. H. Majar Bhuiyan and also heard Mr. S. Nawaz, the learning council for the petitioner. And also heard Mr. S. Nawaz, the learning council for the respond number 4. It is submitted by Mr. Bhuiyan that the conducting council, Mr. Majar Bhuiyan, is not giving back and accordingly paid for an amount, to which Mr. Nawaz raised. Yes, when you want,
Any date.
it will be definitely after vacation.
Yeah,
Our
after
vacation, we don't have any.
29th of July, possible.
It will be due 29th of July.
Yes, madam.
Was there any interim?
Yes, madam.
Interim was there.
Yes, madam.
29th of July, interim be continued till next date of listing.
May I please your lordship, with the consent of the other side, I beg to mention item number 36.
36.
36. Lordship, kindly adjourn the matter for today, lordship. My senior is out of station.
Yes, what about 36? Mr. Parasar?
Yes,
36,
36 we are not there, no customs.
Pardon. Oh, it's a custom.
Custom.
There's an office note
I am on interim lordship.
Next. Objection. They have already filed their objection affidavit in this
Yes,
case.
lordship.
You want an adjournment today?
Yes, lordship.
You are MS?
M. Borwa lordship. I am on interim lordship.
Just a second. You are Mr. MS M. Borwa. Hard MS M. Borwa is being on behalf of MS SPN. And also for the petition. And it is. Have you taken consent?
Yes, lordship.
And with the consent of the others, she prayed for an adjournment, stating that the engaged counsel is having some personal. The office note, it reveals that the affidavit in objection affidavit has already been filed by the other side. Let the matter be accordingly listed after vacation in your 14th of July, immediately after vacation.
Must of less.
May I please, Your Lordship? I beg to announce item number 14.
Interim was not available. Interim be continued.
May I please, Your Lordship? I beg to announce item number 40, my lord, 40, my lord. This is a cancellation of bail, my lord, filed by the state, my lord. Let this matter come after vacation, my report.
With consent of the others, the learned counsel, Mr. D. Bora, the learned counsel, Mr. D. Bora, for the response.
40.
Pray for an adjournment today. Prayer allowed. Please do matter accordingly immediately after vacation and 20. 20.
Deeply, Your Lordship.
May I please, Your Lordship. Lordship, I beg to mention for item number 2 and 5, Your Lordship. Lordship, I'm to be allowed to withdraw this matter. Item 2 and 4.
2 and 4.
Yes,
The councils are same in both the matters or what?
yes. HM
2 and
2 and 5.
or 2 and K. Bhuya was there.
Yes, Your Lordship.
And you are Mr.
HM.
H.A. Ahmed. Hard Mr. Duiter Eke order of hard Mr. H.A. Ahmed. The learned counsel appearing on behalf of Mr. K. Win and submitted that as per the instructions of the petition, he wants to withdraw the same. Considering the submission made by learned counsel for the petition. Prayer is accordingly disposed of both the 2 and 5.
Bless you. May I please, Lordship? Lordship, I would like to mention for item number 13.
1
Lordship,
or 30.
13, 1, 3.
1 3.
1, 3.
Yes, 1 3.
The TCR call for has been received by the registry, Lordship. Kindly a date may be fixed for hearing, Lordship.
For admission hearing.
For hearing,
You are for whom? For the petition.
I am
or
for
the-
petitioner, Lordship.
But have you informed the other side?
Yes,
Ahmed.
yes, Lordship. I have informed. That's what I know.
Of the other side, the learned counsel appealing for the petition for an adjournment. Also, part Mr. A. Parashar, the learned petitioner BP appealing on the state respondent. Prayer allowed is the matter accordingly. No. This scan copy of the TCR has already been received. Is the matter accordingly after vacation. 23rd of July.
Lordship.
Was there any interim?
Yes, interim may be controlled, Lordship.
No, interim was there or not?
Yes, yes.
Was there?
There. Interim is there.
Interim be continued till next.
Lordship. Lordship.
Yes.
May I please, Lordship?
Yes.
Lordship, regular bail application, Lordship. This is second item, Lordship.
This is
Nah.
second bail application.
Second bail application, Lordship. Subsequently,
It
development
is a
is
charge sheet or
charge sheeted, now charge sheeted.
now already charge sheet?
Yes, Lordship. Earlier charge sheet was not submitted, Lordship.
Subsequently charges.
that was rejected. Now subsequently charge sheet has been submitted.
Now appearance stage, my lord. Next.
Lordship,
Case is still at the appearance stage.
appearances, yes, Lordship, in that petition, Lordship, already one accused has been released, Lordship. Now these two, one is Lordship petitioner number 1 is 103 days and 2 is 77 days, Lordship. But charge sheet has been submitted, so my
No,
humble.
days will not count now. What is the stage that
Ma-
case has already
definitely
been
lost.
submitted?
103 murder case, my lord.
Lordship, investigation has been done
It
already.
was
completed.
103.
103 is there.
103.
A scan copy may be called.
That's because, Lordship, one accused has been already released, Lordship.
No,
Now, Lordship,
that I
they are,
cannot say.
they
That
are,
is the
they are ready to cooperate, Lordship. They are interested to cooperate with the trial.
There may be.
By imposing
the
80
ground for
conditions.
bail, I won't say. But the
Definitely.
question is that how can we now at this stage? It's
next
not
that is
possible.
long back, my lord.
What is the next
29/7, my lord. So immediately after vacation, maybe it's the
Next that is 2.
29/7, my lord. Before that, my lord, maybe fix, my lord, calling the my lord PCR.
And the case is pending before the Lordship, SDGM, Lordship, and trial court is session court, Lordship. So, Lordship,
No, I'm not on that. Case is not yet committed.
not complete. Other accusers, they have to be
They're
Yes,
shown
yeah,
as an absconder or what?
absconded. They, in the charge sheet, 3 other petitioner, accused person
They
is
are on bail.
mentioned as absconded, Lordship. But Lordship, actually, immediately after rejection of the bail, that 2 petitioners are enjoying interim protection, Lordship. Immediately after rejection of anticipated bail, after 2 days submission,
They
Lordship,
pled away.
charge sheet has been submitted. So directly it cannot be said absconding also, because after interim, the 2 persons have already appeared, Lordship. And now, Lordship,
No,
Yes,
but
must
but
I-
suppose if they appeared
yes, Lord.
after interim, if they appear, then there is a note, specific note on the IA.
Yes.
On the note of the IO, that after the interim, they cooperated or they that
Yes.
kind of notice there. So
Now
in that case,
They are ready to
They may not
cooperate
be.
as much.
no,
my-
we are not on that. They may not be absconder in that case, but if even after receiving the order of interim, they did not appear, suppose not cooperating, then definitely they will shown as an absconder what to do.
Immediately, Lordship,
No, immediately is different
Truth.
thing, but if they do not appear, then
Yes.
definitely they will be absconder. They will be shown as an absconder.
yes.
Anyway, we are calling for the
And-
scan copy.
okay.
You have given the details here, the scan copy, where is the case is pending? Case
Yes,
number and all?
case number, Lordship,
No, you have not given me.
PRC 201/26, Lordship. I have annexed the charge sheet to be 25, where it is mentioned PRC 201/26.
PRC number
201, Lordship,
201/2026.
26.
Pending before
SDGM,
SDGM,
Bileshivara.
SDGM, Bilasipal. Heard Mr. Hai Islam, Dilani counsel for the petition. Also heard Mr. K.K. Prasha, Dilani additional BP, apprehended for take respondent. Call for the scan copy of PTC as case has already been charged sheeted. Please you will do the note and the record of CRC case number 102, 201 of 2026 pending before SDGM M. Gauhati, Bilasipara, we call for. List the matter. It will be before vacation, so it is not possible. It will be gone after vacation only. After vacation. Immediately we
16th
are
July.
giving 16th,
July.
16th of July.
Okay, Lordship. Report.
Back. 15 সামনে নোটিশ হয়
দেখে কোনো আরে এটা দেখ আরে উপরগুলি কখনো বুঝতে লোকে দেখ পারে Yes, number 4.
We have POCSO lordship. POCSO
POCSO.
substitute notice and TCR.
Heard Mr. S. Muni, Delaney Counsel for the petition. Also heard Mr. K. K. Das, Delaney Petition, PP appearing on behalf of state respondent. Issue notice to the respondent number 2 to jurisdictional police station routed to the office of the registry and the public. Also call for the case date. So when it can be listed.
Can you grant 25 lordship prior to, because everything is in my favor, lordship, the statement and all lordship. She says willingly came. And
Okay.
132
Okay,
days.
listing it on
Notice
25,
complete-
but subject to condition that the notice has to
Oh,
return.
no, that is true, lordship, that,
Okay, then we are listing it on 25.
lordship. Much obliged, your lordship, much obliged.
Make legal lawsuits.
Yes.
The petitioner was arrested on 10/3/2026. Lordship, kindly peruse the FIR, my lord. The lady was, my lord, she is 24 years old, my lord. She is a major. And she came to the accused petitioner's house after falling love each other, my lord. Then after 5 months, she was staying with the accused, my lord. And she left the house, my lord, and filed a complaint case, my lord. That is my case, my lord. And she was refused to examine herself when she took her to the hospital, my lord. That is page, lordships. Page 18, in the last para, the victim refused medical examination. And she is 24 years old, my lord. In the law court, my lord, the session court, my lord, the bail was rejected. That is page 22. Section is, production, tomorrow is the production, fixed for production, my lord. Production of the accused. And he is more than
Under
3
which
months, my
section
lord,
the
in
case is
jail.
registered?
3 months. 3 months, all are 60 days of it.
It's this. No, but the girl is very, no, girl is major, not very
No,
popular.
no, no, but, well, 69 also, well,
69 is, my lord,
up to 10 years. Well,
10 years, yes.
so 60 days offense, well, how 3 months then you entered into default bail.
Otherwise, case is already charged sheeted. No.
No,
Not charge sheeted, my lord.
then
Lordship,
it
can you
will-
peruse the local session court's order, my lord? It starts 21, page 21.
that is of 7/5, my lord.
7/5.
Well,
Then, my lord, 7/5, it was fixed. Then lordship kindly peruse
The
the
evidence.
for
last-
evidence.
for evidence,
Not
yes,
the
my lord.
charge sheeted.
Charge sheeted. Then it was fixed for
I am also
16/6.
just shocked. Why?
Oh, yes, 69.
Evidence, have you, do you have any information?
My lord,
that-
last para, your lordship, this case is fixed for producing an evidence, my lord.
Yes,
It
yes.
was fixed on tomorrow.
Case is fixed for tomorrow.
Tomorrow.
Her evidence is already recorded.
Yes, recorded, my lord.
And,
From where you're saying?
No, I got, actually, I received the copies, my lord, but it was not annexed statement of the accused. Certified, no, I can do copies, this is it. It is not
Now, see,
certified.
this is an order of 7/5, wherein the charge was on that day only, charge was read over to him.
Yes,
And the case was, first case.
Yes,
date
my
of
lord, yes.
Case is 2/6 for evidence.
evidence.
Now you are saying that today, tomorrow is this production day,
Production
not the
and,
evidence day.
production and evidence, it is
Production
written like
and
this,
evidence
yes.
on 2/6.
Last page, my lord.
Yes, on 2/6, what had happened on 2/6?
after 2/6 order to.
2/6, it was
Well,
last
page
page.
24, my lord.
24, last page, lordship. 2/6/2026. Accused Binaroy is produced from jail hazard. He is been returnable to be jail hazard
The
till
PWs were absent
66,
on this.
2026.
Yes, for sure what to say.
Well, ladies are seated, then, well, at this stage, PCR may be called for, well, copy. Before vacation, PCR may be called for her statement. We
I have, my lord, but it is not a certified copy. See, it's admitted. She came to the accused house by herself, my lord, and left by herself, my lord. Because what a measure, my lord. She fall in love with
But
the
was
boy.
there any marriage?
Otherwise, but-
Yes.
Notice is not required, my lord. Immediately, next week maybe call for scan it.
Yes, my lord.
We call for. Raised to
Okay, better, no?
So we can do
Even in that is fine enough.
24/5.
24. Yes. Highly obliged.
May please, Your Lordship. Lordship, anticipatory bail, Lordship. This is also second application, Lordship. The order is at page 22, Lordship. Lordship.
Was rejected.
Is it rejected, Lordship? One is granted anticipatory and the rest are rejected, Lordship. Now, Lordship, 6 petitioners, Lordship. Lordship, kindly at page 7, Lordship. There are 7.
Any new ground after that, my lord?
Is there any
Definitely.
new ground?
Definitely, Lordship. Lordship,
What is the new ground?
Lordship,
Para?
para 7, Lordship. I have mentioned some statement, Lordship. Lordship, earlier occasion when CDOs received, Lordship, some medical documents were missing, Lordship. Now I'm praying, Lordship, up-to-date diary with all the medical documents, Lordship. The incident was taken place, Lordship, on 23rd Street 2026, Lordship. But the medical documents they have submitted, Lordship, it was, Lordship, only the Kokrajhar medical document, Lordship. It was, Lordship, I think 3/4 to 10/4, Lordship. And they have mentioned in the FIR, Lordship, kindly at the FIR, Lordship, page 19, Lordship, kindly, Lordship. In the FIR, they have mentioned, Lordship, after the incident, Lordship, the time was, Lordship, 9:30 to 10 p.m., Lordship. And the local, Lordship, after heard the hue and cry, Lordship, local people,
All this plea that
Yes.
on the last occasion,
yes,
that the Kokrajhar was not mentioned, then Kokrajhar was mentioned, Patna was not mentioned. These things are already you have taken the pleas. Those were discussed in detail in the order.
no, Lordship,
So
now
what is your new ground?
a new grand, Lordship, Patna medical documents not submitted, Lordship. Now, Lordship, the main battle point is that, Lordship, on 23,
Patna document, who will submit?
Lordship, police has to seize the document, Lordship. Patna, they have,
Okay, Mr. Prashan, get it.
Lordship.
After that,
Yes. No, it's not CD. It is, oh, it's a charge sheet, not the
No,
charge
not
sheet.
that, CD, Lordship.
Updated post case diary be called for.
And the main point is, Lordship, they have, police has seized the document of Kokrajhar, Lordship. But before Kokrajhar, they have brought them to Patna. Patna was not seized, Kokrajhar medical documents was seized, Lordship. So kindly up to date CD, Lordship.
After vacation. Say. 15/7. Updated case.
Be published, Lordship.
May I please, Your Lordship?
Yes.
Lordship, notice may be issued POCSO matter, Lordship, in case there
So is a case. Hard Mr. Demeted, Dilani possible debate. So hard Mr. KK Prash, Dilani additional PP. Acting for the state responding. Issue notice to the respond number 2. So judicial administration, director of secretary fee, and the public prosecutor. Also call for the scan for, also call for the TCA.
yes.
It will be after vacation.
Lordship, anticipatory bail application, Lordship, and love relationship between the
No, I can understand every love relationship, but if you need that
Notice
prior
has-
vacation, we
notice
have
has
to
to be
fix
served.
some bail matters and all. So it is an AB anticipated as well, see.
Lordship, if it is not served, then a date may be given, but kindly before vacation, anything.
He's saying prior vacation. I know the date I can get. 25.
Deeply obliged.
তারপর রাখি থবো দে চুলকে দিব লাগা
We have the lawsuit. This is a 482 application lawsuit. FIR is at page 15 also. It's a FIR of 2021 lawsuit.
FI is at page 15.
Page 15 lawsuit.
Yes.
SEBI is in receipt of an email dated 16 June 2021 from Rajiv Aksar Rakshit, wherein he has alleged that a person named Subhasis Kaur from Gosaigaon, Kokrajhar, Assam is collecting large amounts of money from Assam and North Bengal businessmen and giving huge returns in 3 to 12 months. Further, it is stated that Subhasis Kaur is giving out certificates issued by SEBI. In this regard, the certificate purportedly issued by SEBI was examined and it was observed that the certificate has been printed along with the seal logo, email, and phone number of SEBI. It is brought to your kind notice that the said certificate is fake, false, and has not been issued by SEBI. It appears that the credentials of SEBI are being misused by the perpetrators to collect money from various people and misleading them to believe that the certificates have been issued by SEBI. While SEBI is contemplating further actions, as an immediate measure, it was felt necessary to bring this matter to your notice.
Perhaps it is a case of mule account, my lord.
Pardon?
Mule account, my lord, maybe my lord, money transaction, my lord.
Oh, yes, it.
CD is required, my lord.
Lordship, the petitioner is also suffering from Lordship serious backbone problem. Lordship, I have given the medical certificate. And Lordship, the other accused, Lordship, he has already been granted bail. Lordship. At
This case is very serious in nature.
page 32.
My lord, he, against him, my lord, he is the main person.
Page 32, Lordship.
He is the main person. No, maybe bail may be granted to other co-accused. We are not on that. Session judge has already granted. Maybe, but this case is against you. You are Mr. Kaur.
Yes, Lord.
We'll try to call for it. Where from it has
Lordship,
to
I will
come.
cooperate, Lordship, any terms and conditions.
No,
Lordship, I will
let,
be
let us see the case diary. Case is not of that type, na.
Lordship, in that case,
See, the
case
false,
that
this certificate was issued in the name of SEBI and all those money were collected.
that is
It's case
absolute-
of not so thing.
a short date will be given, Lordship, saying only in Sri Montapur, Lordship. Yeah, you.
Montapur, dear, but
Sri
since
Montapur,
2021,
okay.
it is not.
Huh?
Next week will be a motion, my lord.
Lordship.
I
Next
don't know
week,
whether it will receive or not. May not be.
it's from Sri Montapur only.
Motion next is
Sri Montapur is okay, but we have to list the matter, na. Maybe Sri Montapur, maybe from Borpeta also, what is it? আমি কেস হয়েছে পড়তে হয়ে গেল না It will be possible again. Immediately on 13th.
My lord.
Lordship, may kindly before the vacation, Lordship.
Before vacation, we don't have any date. Next week will be a.
Lordship, it will come, Lordship. Already, Lordship. I already appeared before the IO, Lordship. My statement has been recorded, Lordship. Lordship, it will come, Lordship. Lordship, may kindly give the before the vacation, Lordship. Because he's
For
appearing
everyone, it is urgent. So we have to accommodate. What to do?
before vacation, Lordship.
Everybody is asking for before vacation. There are some.
BA,
matters we are
BA,
considered to
in
be
case of
very
BA,
urgent,
we
we are
are
fixing.
also accommodating.
Pardon? It is 21 matter. You are still there.
21 minutes.
Never you searched by police. You are still there. No apprehension at all for your arrest. It will be on 13th of July.
30.
13/7.
Obliged.
Yes.
Met your lordship on, so is there, my lord.
Oh,
My only prayer is, my lord, your lordship, short date before vacation, my lord. We will try, my lord.
you will try. How can we try? That
My
is
lord,
the question.
No, my lord, before, my lord,
Yeah,
vacation,
also, I just say.
various benches are constituted, my lord, before the, prior to the, my lord, holidays, with the vacation, my lord. Some more courts are given, my lord. That's why I'm saying.
Will it be there?
Notice has to be served.
Not that's it. We'll see.
Your information by telling. Till that we don't have any information.
No,
For the
normally
next
what I
day.
am saying, I'm
Huh?
not saying the matter. With authenticity, I'm not saying. Normally what we do, my lord, it happens. Let us see, my lord, if not, certainly we'll do, my lord, 25th.
Mr. H.R. Choudhury, Detained Senior Counsel. assisted by
Yes, yes, sir.
Amit, Delaney counsel for the
TCR may be
sorry.
called.
Yes,
Heard Mr.
Charge sheet.
Rashid Delaney, the additional
From the
PPA.
special judge.
It is a charge sheet case.
Yes, from the special judge, my lord.
Is issue notice to the respondent to jurisdiction of subsidiary
Three women.
public person. Also call for the scan copy of TCR. Scan copy of the TCR. Registry will do the. Huh?
25th.
He's saying we are not in a position still. I have given you 25.
And obliged to us.
May it please, Your Lordship.
Yes.
Lordship, this application is arising out of Lahirighat PS 16 of 2026, where the allegation against me is that, Lordship, I have been a beneficiary of a sum of rupees 1,50,000 arising out of a digital transaction fraud. Lordship, before I take your Lordship to the FIR, Lordship, two similarly situated co-accused have already been granted interim protection by coordinate benches of this Honorable Court. If your Lordship may turn to page number 12, Annexure 1, type copy of the FIR. Your Lordship, this FIR has been filed by RCMS Limited. So they offer certain doorstep banking services to various customers, banks, and financial institutions and financial technology solutions like MPOS devices, so on and so forth. These services are offered through our cash executives employed in the field. Now, Your Lordship may turn to page number 14, paragraph 7. So this direct money transfer service encompasses the request from a customer to transfer money from a person in one location with a bank account to another person with a bank account. Typically, all the bank accounts have a mobile number and the bank account details. Lordship, it's pertinent to note that this service is similar to like a Google Pay or a Paytm transaction service, but instead of digital transaction, here customers can give cash and this cash gets converted into digital cash and then it's transferred to the beneficiary. Now, Your Lordship may turn to paragraph 9 on page 14. So several business correspondent accounts were used to transfer money using DMT services to fraudulently send money from senders to beneficiaries. These BC accounts were deactivated, but the fraudsters somehow reactivated these accounts for fraudulent wallet transfer to other accounts. The details of the BC accounts with the phone numbers used to transfer money from wallet are at Appendix A. The details of the beneficiaries of these wallet money transfers are at Appendix B. The perpetrators of this fraud hacked into the Aceware backend system by some means and used several inactive BC accounts, reactivated these accounts to the top-up recharge wallet balance without depositing any money in Aceware accounts. Thereafter, the perpetrators transferred these amounts from the topped-up wallets to 91 beneficiaries. Now, Lordship, in the next paragraph, I have been identified as one of the 91 beneficiaries, but in no manner am I related to this company which is offering the services. If your Lordship may peruse at 11D, Ashik Rabani. Asikul Islam and Ashik Rabani are the same person, Your Lordship. And an amount of rupees 1,50,000 has been received by Ashik Rabani in his bank account, which is maintained at Federal Bank at Kochi, Kerala, paragraph 12, Your Lordship. Lordship, now police personnel have been frequently visiting my residential premises and there is an apprehension of arrest. Lordship, I am a daily wage earner by profession and I'm also a permanent resident of Morigaon, where this FIR has been lodged.
That you have shown as an one of beneficiary.
One of the beneficiaries, Your Lordship.
Then why police is searching for you?
Lordship.
And you are a daily wage earner, but you have deposited 1,50,000.
No, Lordship. So 1,50,000 has been deposited into my account without my knowledge. So somebody has accessed my account credentials and this money has been deposited into my account. I have no knowledge as to what the services are offered by this company and what the operations are, Lordship. The only allegation is that this amount has been deposited into my account. And as a result, I have been I have been named as one of the accused because this amount is showing as a credit balance in my account of rupees 1,50,000.
In some cases, we have found some accounts has been used as just as a for rent basis. Money will be deposited from different source.
Then he will get some as a
Since
commission.
some in case of interest or money, and he will withdraw the money
Get some
from
amount
one.
of money as a commission.
But Lordship, this is the nature of a digital transaction. As such, there is no risk of tampering the evidence or because everything is digitally recorded, Your Lordship, and therefore custodial interrogation is not as such
But the
required.
question is why such a huge amount of money is deposited in your account
Lordship,
without
we,
having
we are
any
we are
interest
ready to
on you?
cooperate, Your Lordship. That's why we are ready to cooperate as to identify what is the source of this money and how it has has it been how it has been deposited into our account, Your Lordship. I am a permanent resident of Moregaon, and my entire family resides there. So as such, Lordship, the only prayer is that some interim protection may be granted as similarly done for the other
But
co-accused.
you have not received any notice from police? now?
Not received any notice, Lordship, but the police officials, they have been visiting my premises. They have been trying to get information out of me, but no formal procedure has been followed so far.
The case which is annexed case 25, that was interim order and fixed on 11/6. But what happened in 11/6, we don't know. We will check
Lordship,
for that.
so we were appearing in this matter on 11/6. This was fixed, but the conducting counsel, he was not well. So this matter is now been taken up together on 16 July. So all these matters have been connected together. I will place the details of these matters before your Lordship. So these have been connected together and it's next listed on 16 July, Lordship. So until then, interim protection may be granted, your Lordship. I have the order also for 11Z. I have a copy of the order.
Yes, for
In the other case, in the account of the petitioner, 45,000 was deposited. In the petitioner's account, how many?
1,50,000, Lordship.
Without knowing such a huge amount,
But Lordship, also like the other applicants who have been granted bail, in fact, they were the ones who were responsible for recruiting all these persons, like whoever was running this operation. We are in no way connected, and even those persons have been granted interim protection, Lordship, because they are also permanent residents of Moregaon. And Lordship, all these transactions, they are digital in nature, Lordship. Everything is there on record. So as such, the requirement for custodial interrogation is not very clear.
if anything found, next day. it will
custodial
be
interrogation
16.
will be required. Why are not required? The huge racket is going on there.
Lordship.
Transferring the money, you
Without-
don't know this
without
source of
his
money, but
knowledge-
huge amount of it already deposited in your
Lordship.
account.
And nowadays,
So now it has
all
to be discussed where from it is.
all bank account connected through mobile phone. Every transaction, message will come to the
Yes,
mobile. Nowadays,
obviously. You are Mr.
P. Jalan, Lordship.
P. Jalan. Your name is not reflected here.
It's there in the Wakalatnama, Lordship. I'm appearing on behalf of Mr. Amit Goyal.
Heard Mr. P. Jalan, the learned counsel appearing on behalf of Mr. Amit Goel, the learned counsel for the petitioner, and also heard Mr. K.K. Parasha, the learned additional PP appearing on behalf of said respondent. It's an application, section so and so information. It is submitted by Mr. Jalan that the present accused petitioner is innocent. He is no way connected in the office. However, it is a fact that an amount of rupees 1,50,000 had been credited to his account, but without his knowledge and without his knowledge and knowledge he without his knowledge and rather he is one of the victim of the beneficiaries, showing him as one of the beneficiaries in this case, though he is no way related to the said deposit or and is not, and the source of the deposit is also not known to him. The police is now searching for the present petitioner without having his any involvement in the alleged offense. However, he is ready and willing to extend his cooperation in the further investigation of this case and further investigation of this case. And to stop in that context, Mr. Parashar, the learned additional PP, submitted that the custodial interrogation for the present petitioner may be necessary, and hence he insisted to call for the case diary. Considering the submission made by learned counsel for both sides, and also considering the interim granted to the co-accused person by the coordinate bench of this. The present petitioner is also granted with some interim protection till receipt of the case list. So also again liquidable. Other matters are fixed on 16/7.
16/7, Lordship.
Let the matter be accordingly listed in 16/7. And so for the case diary. What are the other numbers of the other matters?
Lordship, AB 1147 2026.
AB 1147
47.
and one is AB 696.
AB 696 2026 and AB 366 2026.
Along which
Lordship, in all these matters, the accused are on interim
16/7.
currently.
16/7 on depot along with sweat. List according. Okay, you will be under interim protection till receipt of the case diary.
Okay.
We will be under interim protection till receipt of the case diary.
Much obliged, Your Lordship.
Already in item number 19, we have received the copy of the notice only. That is not supported with the petition, madam. So the state may kindly be directed to furnish the copy within the course of the day, madam. We have already filed our wakalatnama today, madam, at 10:30.
You have filed your wakalatnama.
Wakalatnama today itself, madam. Day before yesterday, we have received the copy of the only notice, madam.
We will provide today itself. Number 2.
Hard Mr. K.K. Prasad, learned additional PP appearing on state petition. And also hard Mr. P. State learned counsel appearing for the respondent and submitted that they have received the notice only without a copy of the petition. In view of this, Mr. Parashar, learned additional PP submitted that they will provide the copy of the petition during the course. Scanned copy of the DCL has already been received. List the matter after vacation or proper.
Lordship, we may be kindly be allowed to be at liberty to file objection if any, madam, in between.
After
vacation.
16/7, and the respondent will be at liberty to file their written objection, if any, on or before the next date of this. Okay. 16/7. Copy, just furnish the copy of the
I'll do it. I'll provide.
Date to give
16/7.
16/7, madam. Obliged, Lordship.
20. Yeah.
Lordship, item 20, kindly it may be taken up after some time.
Sometime.
Yes. Obliged, Lordship.
Objection is raised.
By reference number
No. 21.
Item 21.
21.
We have received this scanned copy here.
Scan copy received, but name of the respondent also name shown, madam.
Not shown.
We received the objection raised by the reference number 2.
No, council's name are shown here.
Yes, yes, madam.
Now, what do you say? No,
They have
what do you
filed-
want to submit?
They have filed objection also, madam.
Or you have filed objection?
No, they have filed objection. I received.
also, but I am saying, madam, they are not there, madam, because POCSO case.
Oh, it's a POCSO. Oh, अच्छा. So you have-
on
you
the
have-
last occasion, they are not also appearing. Reference 2 is not appearing on the last occasion also, Your Honor. And I am also behind the bar for last 1 year and 2 months, Your Honor. I was arrested on 9th of April 2025.
Madam, maybe taken after some time, madam, learn, PP RJ Boro has gone from, madam. After some time, madam, in the meantime, if, madam, I may be allowed to call that, madam, that's what to Phone number may be there, my lord.
Okay, okay. Just for time being.
May it please your lordship.
Yes, 22 is.
If the charge sheeted case, my lord, TCR is otherwise available. Petitioner is in custody for 171 days. But I'll be fair, my lord, in this case, I have gone through the orders and I've gone through the record. Our contention before this honorable court while filing the bail application was that the section 48 notice, which was served, if your lordship will see at page 20, my lord. '20 and 21, my lord. Lordship has page 20, my lord. So, my lord, the petitioner, number one, is a resident of Rajasthan, and both are from Rajasthan. And this notice was served on one Krishna Saha, my lord, who is from Karbi Anglao. So we took a plea from day one, my lord, that we do not know this person who Krishna Saha is. In fact, we filed an affidavit also in the trial court that we do not know this person. But I have gone through everything, my lord. There is an nomination memo whereby apparently these petitioners have nominated this Krishna Saha. So that plea perhaps may not work, though we have categorically maintained and I have taken instruction from the party. The party says that we do not know. So this is one aspect which perhaps it will not be possible to decide at a bail stage before this honorable court, because it will be again a disputed fact, my lord. So if what I may submit, my lord, because otherwise commercial quantity of contraband was found in his possession, my lord, this person's, my lord. So 37 riggers will come in, and since there is a nomination memo, as of now we cannot go beyond that. So your lordship may dispose it of, my lord, on that aspect, because otherwise we have no other ground. Only prayer I have before your lordship, because a similar matter had also come up in another court, my lord. Same issue had risen up. A liberty was given that at an appropriate stage, the petitioner may be given the liberty of assailing this before the trial court, my lord. Regarding by calling perhaps Krishna Saha as a witness or not, because this will also have a direct bearing on the merit of the case, because he was caught, arrested, at the same time the seizure and all was done, my lord. So tomorrow, if this part is found to be not correct, they will also get a benefit in the merit, my lord. So that liberty may be given, and my lord, matter may be closed otherwise, because no other ground is there, my lord. There's no point in, my lord, dragging it also.
Regarding my lord, regarding merit, my lord, since my learned friend is not submitting anything, my lord, so my lord, I also not make any counter submission, my lord. But regarding 48-day notice, my lord, whatever my learned friend has submitted, my lord, that some observation may be made, my lord, so that he may be called as a witness, my lord. The question is that tomorrow, my lord, she may say it, my lord, that no, I do not know, but do not know anything. I do not recognize the person.
Yes, yes, I can understand.
But question is that, my lord, whatever the 48 notice says, my lord. My lord, if lordship will find my lord, scan copy of the record, my lord, very first portion, my lord. Because the last occasion, my lord, these notices were not available in the record, my lord. Now, my lord, on the basis of the, my lord, submission was made, my lord, that may be called for. So now the 36, 47, 48 notice has been called for, my lord. Now, lordship may kindly see, my lord, what is written in the 48 notice, my lord. That is annexure 21, page number 21, my lord. It is to be noted that the accused person has nominated you as his local guardian, as the above mentioned accused person has been arrested in connection with the above reference case, and he has given his address Gwalnada, PS Kolyanpur district, Balhotra, and his relatives has not yet arrived at this PS. Accordingly, notice 48 under section 48 benefits is served on you, my lord. Accordingly, my lord, the Krishna Saha put signature, my lord, in the notice, my lord. Now, my lord, what does the, my lord, 48 of BNSS says, my lord?
No, it's okay. Mr. Burma, the now question is that the basic point they raise is the 48.
My lord.
That if 48 was issued to some Krishna Saha who is not at all related with that person.
My lord.
They do not know. But now what Mr. Nawaz is submitting that it seems that he was nominated.
Yes.
But nominated,
Yes.
he is also there. Paper is also there.
Yes.
So he is just asking that plea maybe he may have a liberty to take that plea, because Krishna Saha, we cannot go for any inquiry now whether Krishna
Yes,
Saha was
yes,
nominated or not nominated. That much only. We'll going to dispose of the case
Dispose of, my lord,
only with the observation that
That
But-
Krishna Saha cannot be called as a witness because.
No, we are not calling.
Yes.
They may raise that issue before the
Before the
trial.
trial.
That much only.
That we got it.
Otherwise, no issue on that.
My lord.
Because obviously nomination is there, note is also there
Yes,
from
everything
the
is.
IO that Yuvan Krishna Saha was nominated.
My lord.
We'll file an appropriate application, trial court will decide that part only, that part only.
Heard Mr. S. Nawaz, the learned counsel for the petitioner. Also heard Mr. R.J. Borba, the learned petitioner, being on behalf of Jacob's Bank. This is an application under section so and so in connection with so and so. Scan copy of the decision has already been received. Page decision. Next para, it is submitted by Mr. Nawaz that the case is of commercial in nature, wherein the allegation of this recovery of
Recovery of 19.388 kg of opium.
19.3
388 kg of opium.
19.388 kg of opium was an allegation of it. Opium was there against the present petition, and thus the case will also affect the rigor of section 37 and DPS. However, in the present case, the only issue raised by the petitioner was that his family members or friends of the relative were never issued with notice under section 48 of BNSS. And the notice which have been shown to be issued to one, Sri Krishna Saha is no way related to him. However, on perusal of the scanned copy of the PCR and the case record, it reveals that it is as per the note of the IO, the said Krishna Saha was nominated by the present petitioner to receive the notice under section 48 of the BNSS. The notice full stop. Accordingly, he submitted that the petitioner may be given a liberty to raise the issue before the learned trial court bid, as in learned trial court bid. Next para, Mr. Porva, the learned additional PP, raised objection and submitted that there was the 48, there is a full compliance of 48 of BNSS, and from the notice itself, it is seen that as per the, and from the notice itself, it is seen that there was a note of the IO wherein it is stated that accused has nominated his local guardian, said Krishna Saha, to receive the notice on behalf of the petition, as he hails from Rajasthan. More so, apart from that, this is a case of commercial quantity wherein huge quantity of opium was alleged to have been recovered from the poison of the accused petitioner. Next, considering this submission made by learned constable, it is seen that the petitioner has not pressed on the merit of the case, and the issue only raised by the petitioner was that there was no, there was the section, and there was no compliance of section 48 of BNSS. However, during the course of argument, Mr. Nawaz has submitted, and from the record also it is seen that one person, namely Krishna Saha, was nominated by the present accused petitioner to receive notice on behalf of him. Considering all these aspects of the case and the nature of the allegation, the present petition is accordingly dismissed at this stage. However, the petitioner will be at liberty to raise the issue of compliance of 48 of BNSS before the learned trial court, wherein it was stated that the notice was received by one Krishna Saha as per nomination of as nominated by the accused. With the above observation, the present is just disposed.
Keep level.
Yes, 20 also you have.
Yes, madam.
20,
PCR is there, my lord.
I guess TCR is who is speaking, 20.
Yes. Look, in this case, my lord. In this case, my lord, the petitioner before your lordship, my lord, he is a licensed drug distributor, my lord. He has a pharmacy, and your lordship will kindly come to page number 37, man. Page number 37, your lordship will find Jayanti Medical Store, my lord. The petitioner is the proprietor of Jayanti Medical Store, and he has been given a drug license. This is the application, page 38, my lord. The drug license has been issued. 38, your lordship will find this is in force from 2012 to 2017.
No, this was an application.
So page 37 is the application, 38 is the notice, my lord, is the license, my lord.
38.
38 is the license, my lord. Your lordship will see the name of the proprietor, Biswajit Singh, my lord. And this notice is in force from 2012 to 2017. Now thereafter, my lord, subsequently at page, my lord, 41, page 41, my lord, this was renewed, my lord, from 2017 to 2022. My lord.
17 to
17 to 2022, my lord. And thereafter, my lord, at page 44, page 44, my lord, renewed from up to from 2023 to 2027. Now, the petitioner, before your lordship, he was caught by the police while he was carrying 50 bottles of cough syrup in his scooty. And it has been projected that he is a drug dealer, my lord, and so he was arrested and he is in custody for now 268 days. But from these documents, my lord, one thing is apparent that he had a valid drug license, my lord, issued by the competent authority. Now, when we raise this issue before the trial court, my lord, the lordship will find the trial court's observation at page 26. Trial court took issue on 2 points, my lord. First of all, your lordship will see at page 27.
Yes.
Page 27, paragraph 8, my lord. May I read this part, my lord? The learned counsel for the accused has submitted photocopies of a pharmacy license in the name of the accused. But it is revealed from the perusal of the said license that the said license was valid from 29/2012 till 28/10/2017. And thereafter, no license is produced by the accused for the period in question. It is therefore seen that the license, if any, had already expired on 28/10/2017. The learned counsel for the accused has submitted one SBI challan to show that he had paid retention fee and late fee for renewal of license on 15/12/2022. However, it is seen that no license for the relevant period is submitted. Mere paying of late fee and retention fee would not entitle a person to the right over license, but the actual renewal has to be done by the competent authority. Hence, it is held that the accused has failed to show he had any license to run a pharmacy or keep the cough syrups in such a huge quantity in his possession. So what the trial court has failed to observe, if your lordship will again come to the renewals, my lord, it is not just a challan, my lord. Both of these, my lord, they have been stamped and countersigned by the, my lord, inspector of drugs, my lord, of the concerned district, man. Trial court only saw the challan part and made up its mind that this is only a challan. This does not show that the license has been renewed. But in the very challan itself, my lord, the drug inspector, this has already been, the fine has been received.
Challans are where is the challans?
My lord, page 41 and 44, my lord. 44 is more visible, my lord. 44, if your lordship will see. Dipankar Hazarika, Inspector of Drugs, is Karbi Anglong, my lord. This is on 15/12/2022, much before this offense took place, my lord. At the time of commission of this alleged offense, this person had a valid drug license from the competent authority. Now, another issue which the learned trial court took was that the petitioner could not produce the receipts, my lord, for purchase of the cough syrups, my lord. Now there are two aspects, my lord. The petitioner, while the petitioner was coming, my lord, after purchasing this, he was already arrested by the police. So he got arrested and he did not ever get the opportunity of producing these. Secondly, what happened was the moment the person got arrested for this offense, when his family members went to get the receipts, now that seller is not willing to, because the seller fears that if I issue the notice receipts now, he may also get entangled, my lord. But even if we assume that this part is not there, this is at best an infraction of the Drugs and Cosmetics Act, my lord. If there is no receipt, my lord, for that, because this person is, this is not, my lord, ganja or cocaine or heroin, my lord. This is a manufactured drug, and this person has a valid license for the sale of this drug, my lord. The only issue, if lordship may take or the prosecution may object to, was why was this cough syrups in his scooty, and secondly, why the receipts were not there. If that were so, my lord, then this becomes an infraction of the Drugs and Cosmetics Act and not the NDPS Act. And this person has already been in custody for 268 days. Trial is going on, my lord. 3 witnesses have been examined. And from day one, my lord, we have never disputed this fact that this was recovered from us. From day one, we have maintained that we got it from a person because this person is from Bukajan, my lord. He got it from Dimapur, my lord. There has been no suppression on the part of this person, my lord, from day one.
If lordship may take the, my lord, NDPS Act, my lord, section 52(9) of the NDPS Act, my lord, and the section 52(9) of the NDPS rules, my lord.
$52?
52 rules, my lord. NDPS rules,
No, no, no,
section
52.
52, subclause 9, my lord.
Yes.
My lord, may I read, my lord? A licensed
Nine,
dealer or a
not
licensed
yet.
chemist.
52A9.
52, my lord.
A9.
Section 52A9, my lord. Yes, I'm sorry, my lord. 52A9.
Yes.
A licensed dealer or a licensed chemist may possess essential narcotic drugs in such quantity and in such manner as may be specified in the license issued under this rules, my lord. So, my lord, he can stop, my lord, or he can, my lord, possess for the purpose of selling, my lord. But there has to be, my lord, specific, my lord, in the license, my lord. My humble submission, my humble submission is this, my lord.
Specified in the license.
In spite of
It
the
should be
license,
specified in the license.
it should be specified in the license, my lord. Now, my lord, section
No,
52A, my lord.
quantity is to be specified. Just read it. A licensed dealer or a licensed chemist
Yes, my lord.
may
A
possess
licensed dealer
essential
or a
narcotic
licensed
drug.
chemist may possess essential narcotic drug
Ah.
in such quantity
Ah.
and in such manner
Ah.
as may be specified in the license issued under these rules, my lord. Because there in the license, my lord, there has to be mentioned, my lord. Suppose assuming, my lord, he is allowed to, my lord, store 50 bottles of cough syrup, my lord. He cannot store 100 bottles, my lord. Even he cannot, my lord, store 60 bottles also, my lord. If it is mentioned in the license, my lord. Now, secondly, my lord, section 52A, my lord. Possession of essential narcotic drugs. No person shall possess any essential narcotic drugs otherwise than in accordance with the provision of these rules, my lord. Now, my lord, who are the, my lord? The person, my lord. Any person may possess an essential narcotic drug in such quantity as has been at one time sold or dispensed for his use in accordance with the provision of these rules. A registered medical practitioner may possess essential narcotic drugs for use in his practice, but not for sale or distribution, not more than the quantity mentioned in the table below, namely, my lord. Now, my lord, in the table, my lord, that has been mentioned, my lord. That what are the, my lord, next page, my lord, notable fine. The table is given, my lord. Even the registered practitioner also, my lord, they cannot possess except, my lord, specified in the table, my lord. Now, my lord, coming to the fact of the case, my lord, if lordship may
Now,
kindly come.
these are kind of what kind of thing you now see?
My lord, these are the, my lord,
One morphine,
if section,
methanol
lordship will
morphine,
follow section 52A, my lord,
codeine,
my lord, morphine, my lord. One is morphine, my lord, that is quantity is 500 milligrams, my lord. Then methyl morphine, my lord, commonly known as codeine, my lord.
Ah.
That is, my lord, comes into a capsule of, my lord, codeine.
yes, generally comes.
2000 milligrams, my lord. 2000 milligrams means, my lord, 100 milligrams, my lord, it will be around 20 bottles, my lord. 2000 milligrams, my lord. Now, my lord, if lordships come to my lord, page number 23, my lord. It's a part of the search sheet, my lord.
23.
Page number 23, my lord.
Yes.
Lordship may, if lordship, my lord, peruse the last paragraph, my lord. Hence, on completion of the investigation process, the presence of codeine is confirmed in the test capsule bottle. Codeine is a narcotic substance which are highly addictive drugs that affect central nervous system. It is an illegal drug with high market value, and its use have immense medical, social, and economic consequences. Total 50 bottles of cough syrup containing codeine phosphate was seized from the possession of the accused person, which is commercial quantity. During the course of investigation, the arrested accused person was caught red-handed while carrying the cough syrup illegally and without any valid documents. My lord, this is important, my lord. During interrogation, he revealed that he has purchased the said cough syrup bottles from an unknown person of Dimapur, Nagaland, for personal consumption as well as to sell in his retail in Bukhajan area. So during investigation, my lord, these materials were found, my lord. My understanding is submitted, my lord, he is an authorized dealer, my lord, and he has procured those cough syrup, my lord, to sell in his pharmacy, my lord. Yes, my lord, he can sell it, my lord. If he has got a license, my lord, there is no bar, my lord. But question is that, my lord, when he will purchase the cough syrup, my lord, for selling, my lord, he will definitely obtain in, my lord, cash memo, my lord, that I have purchased 50 bottles of cough syrup from this shop or this, my lord, wholesaler, my lord. Then, my lord, there would have been no case, my lord. Now he could not produce any documents, my lord. First, my humble submission, my lord. Secondly, my lord, he was caught while carrying the cough syrup illegally without any valid document, and he has stated, my lord, during his interrogation, my lord, that he has brought this cough syrup from Nagaland, my lord. Now his license is valid for Assam, my lord. He cannot go to another state, my lord, to purchase cough syrup, my lord. And lordship may kindly see, my lord, the annexure 6, my lord. This is the, my lord, license, my lord, probably, my lord.
Yes.
My lord, this license is issued by the, my lord, Joint Drug Controller Headquarters, Gauhati, my lord. That is, my lord, this is applicable to only Assam only, my lord. He is not required to go to, but if the person is from Assam or Guwahati, he is not required to go to, my lord, Shillong to purchase cough syrup or to, my lord, Arunachal Pradesh. Now, this person, my lord, he is from Karbi Anglong, and he went to, my lord, Dimapur to purchase this cough syrup, my lord. So, my humble submission, my lord, regards of 37 will also come, my lord, in this regard, my lord. So, at this stage, my lord, I am opposing, my lord, this bail application. And secondly, my lord, my understanding had already read out the order dated 21/2026, my lord, when the trial court has observed everything, my lord, regarding the license also, my lord, and the, my lord, the cough syrup bottles of cough syrup bottle, my lord, what is the percentage of the codeine, my lord, that will be, my lord, applicable at the time of trial, my lord. So my humble submission, my lord, because of 37 will come, my lord. So at this stage, my lord, I am opposing this bail.
My learned friend has read out 52A. Now, one thing, when the trial court has given a finding, that is why we are before this honorable court, because the finding of the trial court is not final, my lord. Your lordship will independently examine. Now, 52A, my learned friend has read out, saying that registered medical practitioner should have in his possession only up to a specified amount. So, my lord, registered medical practitioner and a license holder are two different things, which my learned friend has not read out. Your lordship will see 52A for a moment first, my lord. He has read Rule 3. A registered medical practitioner may possess essential narcotic drug for use in his practice, but not for sale or distribution, not more than the quantity mentioned in the table. Now, your lordship will kindly come to the rule 2, my lord, 1B, 2IB, my lord.
52I.
50, no, my lord, rule 2.
Rule 2.
Rule 2, I, then B, my lord. Perhaps your lordship, if your lordship is the same book.
52 rule 2 or what?
No, no, no. Only rule 2.
Acha,
Definition
rule
part, my lord.
Acha.
The starting of the rules, my lord. Registered medical practitioner basically in terms of this is, my lord, doctor, dentist, or any other person. So the IB, if your lordship will have second page, my lord. Registered medical practitioner means any person registered as a medical practitioner under the Indian Medical Council Act or under any law for the registration of medical practitioner for the time being in force, or registered as a dentist.
So again, 2I.
IB, my lord.
Acha. Yes.
So it means any person registered as a medical practitioner under the Indian Medical Council Act or under any law for the registration of medical practitioner for the time being in force, or registered as a dentist under the Dentist Act 1948, or under any law for the registration of dentist for the time being in force, and has undergone training in pain relief and palliative care for prescription of essential narcotic drugs for pain relief and palliative care, or training in opioid substitution therapy. So this is basically, my lord, medical practitioner from what one understands from this definition is, my lord, a doctor or a dentist, my lord. So the rules say that a doctor or a dentist can only have in his possession a particular amount of these manufactured drugs, my lord. This rule will not be applicable to a, my lord, a drug license, my lord, drug distributor, my lord. So what my learned friend.
He also stays upon 52.
Yes, my lord. I'll come to that part also, my lord.
52A9.
52A9, my lord. A licensed dealer or a licensed chemist may possess essential narcotic drugs in such quantity and in such manner as may be specified in the license issued under these rules. Now, the license your lordship will find at page 38, my lord. But the licensing authority has issued this license. This is not my document. The licensing authority has given in the top part, my lord, license to sell, stock, or exhibit for sale or distribute drugs by retail other than those specified in Schedule C, C1, and X for independent vendors and other dealers who do not engage in services of a qualified person. Now, this license itself has not given any quantity, my lord. This is not my document, my lord. Now, if the licensing authority has not specified, my lord, it has also not specified 1 bottle or 2 bottle or 10 bottles, my lord. And this license is in fact issued under the Drugs and Cosmetics Act, my lord. Now, if the reasoning of my learned friend is to be accepted, then this person will not be able to sell anything because it does not mention any quantity, my lord. At one point of time, the state is issuing him a license. And at the same time, the license does not say the exact amount, my lord. And the other aspect regarding Dimapur, my lord, so most of the medicines, my lord, or drugs, they are coming from outside state. There is nothing which in the act which says that a person cannot procure manufactured drugs or any other medicine from beyond Assam. The license is for the purpose of selling it in Assam. If he had sold it outside Assam, then it would have been an offense, my lord. Purchasing all the drugs, hardly any drugs are being manufactured in Assam, my lord. So most of the drugs or medicines are procured from outside Assam. There has to be something in the law which says that I cannot buy from outside Assam. License is for selling. So when the state of Assam is issuing a license for selling, so what is understood that the person cannot sell beyond the territory of Assam. Now, if this person has sold it in Dimapur, then it's a different thing. But purchasing, then the act has to say something that you cannot purchase from outside Assam. That is not there. Nowhere in the statutory provisions it is there that a person cannot procure anything from outside Assam. So this person is not a drug peddler. He is not selling ganja, opium, or any other thing. He has been given a license, particular amount, and this is not a huge amount. 50 bottles has been found in his possession, man. He has a license to sell, man. All other aspects of trial court will consider, but prima facie, my lord, at least on the basis of this document, lordship can form at least an inference, my lord. This person has not committed a violation of the act. And assuming, my lord, there has been an infraction, it would at best be an infraction of the Drugs and Cosmetics Act, my lord. So regards of 37 may not come, my lord.
The 10 bottles become commercial quantity, well. 10 bottles of cough syrup for a pickup commercial quantity, my lord.
Yes, yes.
And in this case, my lord, 50 bottles has been recovered and seized.
Hard, this number. Hard Mr. S. Nawaz, Ilan also repeated. Also hard Mr. R.J. Borba, Ilan additional PP, appearing on behalf of state respondent. Sections 2 and 3, scan copy of the TCR has already been received. Where is received? It is submitted by Mr. Nawaz that the present accused petitioner is innocent. He is not a drug peddler, or neither he deals with any business of drug. He is a pharmacist and has and also obtained the drug license from authorized by the licensing authority of drugs and cosmetics licensing by the drugs and cosmetics licensing authority. Initially, his license was issued for the year 2012 to 2017, but thereafter, in two occasions, it was renewed and that is from 2017 to 2020, and finally from 2022 to 2027, the license was renewed, and on the basis of the renewed license, he is doing his business. He was caught along when he was coming by with 50 bottles of cough syrup in his scooty, and without giving any opportunity of producing the receipts and all, he was been apprehended by police. At present, he is in custody for more than 268 days, 8 days, 8 days post. He further submitted the learned trial court below did not consider the fact that the license was issued by a competent authority and he had possessed the license since up to 2000, and his license was renewed by 2027. But while dealing with the bail application, the learned trial court below basically stress on the point that the license was valid from 29/10/2012 till 28/10/2017, and that is his license was expired before his arrest. Before his arrest, and it was also considered that it was only the documents which were produced is only challan, and there is no only a challan on the basis of which it is claimed that the license was renewed. But from those renewal license, it is seen that the authority has already put their seal and signature in the renewal license, and it is not merely a treasury challenge, but the license was renewed accordingly. But that aspect was not considered by the learned trial court below while dealing with the application for bail. He further submitted that at the time of his arrest, he could not produce the money receipts, as during that period of time when he was purchased, the money receipt was not generated, and subsequently his family members who tried to get the money receipt, but it was not issued by the person from whom the cough syrup bottle were purchased, with the apprehension that he may also be entangled with the present case. He further submitted that even if he could not produce any receipt, in that case also it may be a case under the drugs and cosmetics Act, and it cannot be a case under the NDPS Act to attract section 37 of the NDPS Act. He is a permanent resident of his address locality, and considering all these aspects of the case, he may be released on bail. However, he will appear before the Iran trial court below as and when his date is fixed for. Date is fixed first. Next, Mr. Burwa Iran additional PP raised an objection and submitted that as per the rule of 52A9, A9, a licensed dealer or a licensed chemist may possess essential narcotics drugs in such quantity, and in such manner as may be prescribed in the license issued under these rules. But here in the instant case, the petitioner and a commercial quantity of 50 bottles of cough syrup were recovered from the possession of the accused petitioner, and petitioner he further submitted that being a pharmacist or chemist, he may keep the cough syrup bottles for sale or for his personal consumption, but there has to be a limit for keeping those bottles as per the license issued to him. He further submitted that as per 52A, as per rule 52A of subsection 3, there has to be some specified quantity of the drugs which is to be kept with a registered medical practitioner, and beyond that limit, he cannot. One cannot keep such a huge quantity of the medicine or the manufactured drug in his medical store.
My lord, may I add, my lord, one more submission, my lord? As per the license, my lord, he is authorized to sell only Schedule C and C1 drugs, my lord. And my humble submission, my lord, this cough syrup will come under the Schedule H drug, my lord, of the drugs.
Just a second. Schedule?
My lord, page
As
number
per
39.
license.
Page number 39, my lord, the license, my lord.
Yes, schedule.
Schedule, lordship may kindly say, my lord, 1, 2, and 3, my lord. The following drugs being drugs specified in Schedule C and Schedule C1, the Drugs and Cosmetic Rules 1945, subject to the conditions specified below and to the provision of the Drugs and Cosmetic Act 1940 and the rules thereunder. The license will be enforced from so and so. Particulars of Schedule C and C1 drugs to be sold, my lord.
My lord will kindly
C
see.
and C1.
C and C1, my lord, yes. Only such medicines where the services of a qualified person, this, my lord, that is not complete, my lord. That is, my lord, that is on prescription, my lord.
Where is the C? Schedule C?
My lord, particular Schedule C and C1 drugs.
Yes, where from will get now?
Drugs to be sold, only such medicine. It is
No,
written.
no, C and C1. Where from you're saying C and
Yes,
C1?
C1, C1, my lord. I have a,
One thing
I
just
have a
just I will point out, my lord. My
Yes, sir.
lord friend has not read this correctly. So lordship will see page 38, the top part, my lord. Other than C, C1 and X.
Oh,
Other than C, C1 and X. First part, my lord.
page 38.
38, my lord. License to sell, stock, or exhibit for sale or distribute drugs by retail other than those specified in C, C1 and X.
no, that was, my lord, up to 2017, my lord.
These are
No,
two same
no.
licenses.
His license was issued. Which one are you reading?
My lord, page 38.
Page 38.
38.
Para?
Page 38, the first part, my lord. Heading, my lord.
Acha. Oh, acha.
It's other license to sell, stock, or exhibit for sale or distribute drugs by retail other than those specified in C, C1 and X. So not X. So codeine is Schedule H. So I am entitled to sell H. I am not entitled to sell C, C1 and X. Other than C, C1 and X.
So then, but 39, my lord, again it is mentioned, my lord, particulars of Schedule
Yes.
C and C1.
So there are two licenses. 61 is 38 is under Rule 61(1). 39 is under 61(2). So under 38, I am entitled to sell and distribute drugs other than those specified in C, C1 and X. And in 39, I am entitled to sell drugs for C and C1. So 38 says C, C1 and X I cannot sell. That's a general license. All other scheduled drugs I can sell. Then another license there where I am able to sell C and C1 also. So the only license drug which I cannot sell is a Schedule X. And codeine is a Schedule H, as my learned friend has pointed out.
Couldn't come under Schedule H.
H. So Schedule H I am entitled to sell.
Then I don't make this submission. It will make some confusion.
Okay. Dr. Lasper, go tell it. Mr. Borua further submitted that during the investigation also, it is seen that the that 50 bottles of cough syrup containing codeine phosphate was recovered from the possession of the present petition, and the codeine is confirmed and codeine is also confirmed in the seized cough syrup, which is a highly addictive drugs and affect the central nervous system. Apart from that, he purchased all those drugs from Dimapur, Nagaland. So the license was issued to him from Assam Drugs and Cosmetics Authority, licensing authority. But it revealed that he purchased those cough syrup from the state of Nagaland. In that context, Mr. Nawaz, the learned counsel for the petitioner, submitted that as per the license issued to him, there was no specific mention about the quantity to be sold by the present petitioner, and that apart, the rule 52A sub-rule 3 speaks about only the medical practitioner, and as per rule 2 small IB, the present petitioner cannot come under as the term of medical practitioner. Further, he submitted that it is an admitted fact that he purchased those the bottle of cough syrups from the state of Nagaland, and there cannot be any bar for purchasing the drugs from outside Assam. So he is authorized only to sell any drugs in Assam only as per the license issued to him. He further submitted that the petitioner is not at all a drug peddler, but without giving any opportunity of producing all these documents, he got arrested in connection with this case and is in custody for last 268 days. Accordingly, Mr. Nawaz further submitted that he may be released on bail stays.
In the evidence, she has categorically stated Utpal Raj. In evidence part. Both one is the 183. No, yes, in the evidence, both the names of Vijay's name also there. In 183, subsequently, Paul Robidas' name has come. Now, they have filed a petition also Utpal Das alias Paul. In the petition itself, name is.
Yes, I am not taking that ground. I have only pointed out, Your Lordship.
Now, I have trademarked the birth certificate, my lord, she is around 13 years at that point of time. When the evidence recorded, she is 14 years. And evidence part, my lord, she has categorically stated, my lord. Now, my lord, regarding both the person may be, my lord, because regarding what pregnancy by whom, my lord, it will be, my lord, matter of trial, my lord. It can be, my lord. But at first statement of the girl, and specifically stated, my lord, subsequent to that, my lord. And one thing is that, my lord, she loves this Paul, Utpal. But Vijay is his friend. Vijay is his friend. Subsequently, first incident with Vijay. But around 4 times, sexual intercourse with Utpal also, my lord. As per, my lord,
My point is this, Your Lordship,
evidence.
that she has implicated, Your Lordship. Ultimately, I will have to face the music, Your Lordship, when this trial ends, Your Lordship. Now, the purpose behind putting a man behind bar, Your Lordship, is that, Your Lordship, that's so that he cannot influence the victim or the material witnesses, Your Lordship. Now, mother and victim has already been examined. Therefore, they don't also have any objection.
She admitted that with both the,
Yes, Your Lordship.
she had.
Yes,
They have-
both, maybe, my lord, as per her, both on different times. And but I'd like to point out one thing, my lord, for this court, my lord. Another case, it may not be similar, but the POXO case, on the first instance, my lord, respondent has appeared that we have no objection. But on our objection, court didn't give bail, my lord. Subsequently, he got bail after the, my lord, statement of the victim and accused raised. And that boy, after coming from jail, my lord, 17 times stabbed the girl, my lord, last month's incident.
You, I will not be able to go there, Your Lordship,
My lord,
with her.
Malat, when this in 13 years girl, 13 years, when the incident happens is 13 years. And there is no objection from the side of the respondent informant come we have doubt about it.
Lordship will kindly see these kind of, Your Lordship, that is putting, Your Lordship, these are purely on presumption. Can these kind of submissions be made by the learned people, Your Lordship?
This man, he is appearing for the murder, informant is a mother. Mother may not have, what going on with that girl, she was at that point of time 4 months pregnant. Now, what is the situation? I don't know.
No, it is, the record is there, Your Lordship. With her consent, immediately after the FIR, Your Lordship, abortion was done by the police, Your Lordship. That is there, Your Lordship. Now, putting me behind her, what purpose?
You appear through Vakalatnama, isn't it? So you have that instruction.
Yes.
You rightly pointed out, Mr. Parasar, that it happens.
I'm not saying all
All states, definitely.
but when
it is
in
not
such
the
type
case,
of
it cannot
13
be
years
the
girl,
case.
if the girl is of 17 years or 17 years, 5 months, 16 above, another thing. 13, 14, 12 years, when such type of no objection come, we have definitely some doubt about it.
But now the PW1 is the victim and who got examined?
PW2 is the mother.
That is the informant.
Yes, sir. Both were examined, Your Lordship. And these are the two material witnesses, Your Lordship. Presuming something, Your Lordship, happening somewhere, Your Lordship, 100 of cases, Your Lordship, such happened. I am not on the merit of the case, Your Lordship. That will be dealt with at the time of trial, Your Lordship.
I'm submitting because such type of no objection in generally not come. One, two cases chance has come because of
why it has come, Your Lordship will find from the statement of the witness, Your Lordship. And without, Your Lordship, examination of the PW1 and PW2, I would not have approached this honorable court, Your Lordship, only because of that, Your Lordship. Now, ultimately, we are at the stage of grant of bail, Your Lordship, not And bail cannot be withheld as a punishment. Your lordship knows very well. I don't have to reiterate that, your lordship.
Part Mr. S. Waterford, Delaney Senior Counsel, assisted by Mr. D. Gogoi, Delaney Counsel for the petition. Also heard Mr. K. Prasha, Delaney Additional VP, appearing on behalf of the respondent. And Mr. K. Dana, SD, Delaney Counsel, appearing for the informant of the respondent. It's an application, the section so in connection with scan copy of the case has already been received. Fails decision. Next, right, is submitted by Mr. Waterford that the present accused petitioner is innocent and he has not committed any such offense as alleged. The case was the petitioner is in custody since last 6 months, 1 year, and he got arrested on 22/3/2025. 2020, more than 1 year, he got arrested on 22/3/2025. At present, the trial has already been initiated, and two witnesses have already been examined, including the victim and the informant of this. He further submitted that initially in the FIR there is no utterance of about the present petitioner, and her statement was also recorded on 11/3/2025, wherein she did not brought any allegation against the present petitioner. However, her another statement was recorded under section 183 PNSS on 18/3/2025, wherein she brought some allegations of sexual assault on her by the present accused petitioner. This he submitted that the two trial is going on independently, wherein she named another accused initially and subsequently she also brought the allegation against the present petitioner. However, the present petitioner is who's a permanent resident of his address locality, and there is no chance of responding if he is granted with bail. Rather, he will regularly appear before the Learned Trial Court below, as and when the date is fixed for the trial. Further, he submitted that as the victim and the informant, the vital witnesses of the prosecution has already been examined, the question of hampering with the evidence of the other witnesses also does not arise. Next one, Mr. Parashar, Learned Additional PP, submitted that the victim is a 13 or 14 years old girl, and she implicated both the accused persons, including the present petitioner, with whom he had who did penetrative who did the penetrative sexual assault on the victim. He further submitted that the statement of the evidence of the victim as well as the informant is recorded, but there are some other independent witnesses who were yet to be examined by the prosecution, and hence raise objection in allowing the petition to go on bail at this stage. Next point, Mr. Day, the learned counsel appearing for the informant, submitted in this regard that there's a what is the submission? Is there any compromise? Sensual. Submitted that it was an consensual relationship between the victim as well as the accused petitioner, and hence, as per his instruction, the informant of the respondent number 2 has no objection if the petition for bail is allowed if the bail is allowed for the present petition. Mr. Parashar, however, submitted in this regard that this that the informant is the mother of the victim, and on her behalf, she made a compromise, and compromise that the victim may not be aware about such compromise, and sometimes it may also be dangerous for the victim if the accused petitioner is released on bail at this stage. Next paragraph, hearing this submission with consequent questions and also with case record and the scanned copy of the paper, including the statement made by the victim under section 183 of PNSS. It reveals that her statement is recorded in two occasions wherein she implicate the present petitioner in her subsequent statement, and from her evidence also it is seen that she implicated both the accused person, including the present petitioner. However, it is seen that the statement of the victim as well as the informant has already been recorded, and hence question of tampering with the evidence of other vital witnesses does not arise at this stage. Apart from that, it is as per the submission made by the learned and case counsel for the informant, the relationship was consensual, and hence the informant has no objection even if the accused petitioner is released on bail at this stage. Considering this submission made by learned counsel for both without going detail into the merit of the case, and also considering the fact that the victim and the informant of this case has already been examined, this court is of opinion that the accused may be granted with the privilege of the sources. Okay, you're granted with bail.
Lordship.
My lord, in this case, the petitioners are in custody. There are 5 number of petitioners. They were arrested on 19/4. As on today, they have completed 57 days in custody. And this is the second occasion this bail application has been filed. Earlier, this bail application was rejected by your honorable court on 22/5/2026 on the ground that there is scope for further custodial interrogation and other accused person are yet to be arrested. But as far as the present petitioners are concerned, Lordship, since their arrest, they were never subjected to police custody. In fact, after this incident, Lordship, they were called to the police station, and being conscious, law-abiding citizen, they have voluntarily appeared before the police station. And on the next date, when they were produced before the magistrate, police did not seek any police custody, Lordship. They were straight away sent to judicial custody. And since last 57 days, they are in jail. Even the investigating agency did not seek the permission of the court to ever subject them to interrogation in jail. So they were not subjected to any interrogation by the police till date. As on today, they have completed 57 days in custody, Lordship. That case, Lordship will remember that the group had assembled in front of the house of the accused number 1. Accused number 1 and the victim were having an affair, and this person was intercepted by the villagers, and in a mob attack, this victim was killed, Lordship. His body was recovered from a nearby railway line. Now, after the occurrence, these petitioners were later arrested. First, a batch of around 6-7 persons were arrested. Subsequent thereto, after the arrest of the main accused person, these persons were called to the police station. They appeared before the police station, and after they appeared before the police station, Lordship, they were arrested in this case. So as on today, Lordship, they have completed 57 days, Lordship. Otherwise, also in this case, case study will reveal a specific, Lordship, involvement, Lordship, will have to be there. Randomly, police picking up persons on the basis of some suspicion, already they have completed 57 days in custody, Lordship.
The alia rejection order is page number 53, my lord. And Lordship may kindly peruse, my lord, page number 54, para 8, my lord. Page number 55, paragraph number 8.
Yes.
He was only 19 years old, my lord, and there is no fault, my lord. Only fault is that, my lord, he loved the girl, my lord. And as per the, my lord, request of the girl, he went to the house, the, my lord, girl, my lord, at 11 o'clock, my lord, in the night. Then, my lord, they somehow, my lord, they came out from the house, my lord. That is the allegation, my lord. What I have found from the case there, my lord. They came out from the house, my lord. Then when, my lord, the family members of the girl found that, my lord, she is not at house, my lord. Then they start searching the girl, my lord. And initially, the girl was recovered, my lord. Thereafter, the my lord, boy was caught by the villagers, my lord. And he was brutally, my lord, killed, my lord. He was only 19 years of age. And postmortem report also received, my lord, multiple injuries. My lord, he sustained multiple injuries. And witnesses have implicated, my lord. Yes, I leave it to your lordship.
From them, it appears that the matter is a serious one, Lordship. They ought to have taken due in the investigation, Lordship, nothing from the investigating agency. This shows the level of seriousness in the matter. 57 days in custody when Lordship also observed that there is scope for further interrogation since other accused persons are yet to be arrested. And police have not taken the order also seriously. So this aspect of the matter has also to be appreciated, Lordship. The very fact that police did not even seek their police custody after their arrest. And these 57 days, Lordship, the investigating agency got ample opportunity, Lordship. They could have sought the permission of the court and went to the jail to record the statement of the accused. That was not done. After 57 days, this is the submission that it is a serious case, Lordship. It is a serious case, Lordship. Then the investigating agency ought to have taken steps to record their statements. The investigation was not done properly by the police. And they are not even a FI named accused person.
It was a mob, so particularly all the name of the accused persons may
No,
not be mentioned.
not
The
that.
mob attack. Apart Mr. A. Ganguly, the Lieutenant Master for the petition. Apart Mr. R.J. Burwa, the Lieutenant Additional PP, appearing on behalf of state respondent. It's an application of the section so and so in connection with so and so. City receipt, failed receipt. Next paragraph. It is submitted by Mr. Ganguly that the present accused petitions are innocent and they have not committed any such offense with the alleged state. However, these petitioners are named also not the FI named accused. And coming to know about the incident, they themselves appeared before the police station on being asked, and then only they got arrested. They got arrested and sent for judicial custody. Police never sought for any police remand for these petitions, and till date they are in 57 days in judicial custody. But during the entire period, the police never interrogated them, even inside the jail premises. However, all the petitioners are still ready and willing to extend their cooperation if it is needed for further investigation of this case. Next. Mr. Borba, the learned additional PP, is objection and submitted that this is the subsequent bail application, wherein the earlier bail application was rejected for the present petitions. And he also submitted this is a very serious nature of case, wherein a 19-year-old boy had lost his life due to an mob attack only because he came to meet his girlfriend on the night of that occurrence. Mr. Borwa further submitted that the investigation is still under process, and hence further custodial interrogation may be necessary for the purpose of investigation. Hearing this submission made by any counsel for instance. So Peruji is recorded. And without going the detail into the merit of the case, it is seen that I got sufficient opportunity to interrogate them, keeping them in custody for 57 days. Hence, further custodial detention may not be required for the purpose of investigation. In view of this, This court is of opinion that the accused petitions may be granted with the privilege of bail, privilege of bail and extended concessions. It is for whose satisfaction? Whose satisfaction?
CGM Kamrup Metro.
CGM.
I'm obliged.
As per no obvious note, my lord, environment received a notice. So
Oh,
actually,
did anyone appear?
No, not sure.
my lord, actually, POCSO, a loss of quality, no offense has already been committed. No offense, a loss of quality affair.
Acha, okay, then we'll
Amicus
do
curiae
one
has
thing.
to be appointed.
While we appoint an amicus curiae and prior vacation will be put in.
Yes.
Art Mr. J. Amity.
On 18, it may take 17.
It is submitted that notice on respondent number 2 has already been served, but no one has represented the respondent number 2. In view of this, let an amicus be appointed to represent the respondent number 2. And accordingly, let MS Sanjana Neighbor be appointed as the amicus to represent the respondent number 2. The registry will do the needful in providing the relevant copies to Ms. Neighbor.
17 or 18, my lord.
Huh?
This may be 17 or 18.
What 17? Tomorrow.
Day
Day after tomorrow.
Oh, yes.
Very not. Get it.
Then 18, my lord.
23rd of this month. Somehow we managed to give you 23. 17, 18, all are full. Yes, 33 we have received here. Is there any? Scan copy?
Scan copy of TCL corporate.
Scan copy of TCL.
Yes.
Again, last page it is
No, Lordship, I'm sorry. It's CD, not ministry.
CD.
It was called for CD, Lordship.
Pardon?
It was called for CD. Is
Acha.
died, Lordship.
CD not received, I'm sorry. Interim or something?
Interim.
Petitioner is an interim, Lordship.
You are MS?
J Das, Lordship.
MS J Das, still on a petition. Also heard MSSH for still on a petition.
Interim may be continued, Lordship.
Appearing on set. City not received. Issue reminder. Interim may continue till next listing. List accordingly, yes.
Lordship, after vacation, maybe.
22nd July.
Much obliged.
My lord, I'm sorry, my lord. Item 32. It may be 22 or 24, my lord. 23, I have difficulty. 22, my
Will do.
22.
24 করে দিব ব্যাস কি 32
Maybe.
yes yes what about 34
CD is not a malot, but however, malot, Lordship may take up the matter considering the nature of allegation made in the
anyway
affair, malot.
CD we have received
Not received, Lordship.
why not received
34, no?
Yes.
Lordship, we have sent out intimation, Lordship. That is on 26/5, again, we have sent our intimation.
because interim was granted on 6/2/2026 incidentally matter is pending
Yes, Lordship.
awaiting for this
Possibly, Lordship, the CD may not be required.
Kindly give us a
as we peruse the materials on record, what my lord is reflected in the imbuing order, my lord, as well as grant of bail order, my lord. It is clear, my lord.
Since Lordship 6/2/2026, we have sent our intimation on several occasions, Lordship. 6/2, then 27/2, then 26/3, then 24/4/11/5, and last year on 26/5.
If lordship peruse page 22, my lord.
Now, in the, while passing the order of interim, Lordship, most probably on that day, order dated 19/1/2026 passed by session judge, Nalbari was placed before. And it was seen that the injuries upon the informant and his wife were found to be simple in nature. That is why most probably he is submitting that it may not be a case or even for case died. So, but other sections are there, I don't know. 61 to 126 to 304, 351, 296, 329. These are the sections, including 76 and all. But obviously 1181 was there, so may not be a case of 118. But I don't know about the other matter. So CD will reveal Lordship. Now, see, Mr. Counsel, the question is that obviously you are rightly submitted that there may not be a case of 1181. Injuries may not be of previous in nature as observed.
Possibly, my lord.
Possibly. But what I'm saying, the other marriage, we cannot say anything at this stage. So we'll do one thing.
Otherwise, other co-accused also already granted bail.
Bail, na?
That is what.
Okay, and heard Mr. N.K. Mori, the learned counsel for the petition. Also heard Ms. S.H. Kora, the learned additional PK, appearing on behalf of said respondent. C did not receive, to stop, no intimation received from the I. On submission made by learned counsel for the petitioner as well as from the orders, it is seen that the interim anticipatory bail was granted to the petitioner on petitioners on 6/2/2026, and since then the CD was called for by the court. But till date, the IO could not furnish the case died, in spite of sending several signals to him. In view of this, the IO is hereby directed to furnish the case diary positively on or before the next date of listing. In default, he may be served with a personal show cause. List accordingly in the 17 July will do.
All right.
17/6/7. Interim be continued till next.
Actually, a copy of the order may be furnished.
A copy of order may be furnished along with the notice to the IO.
And interim continue, my lord? Interim continue, my lord?
Yes, sure.
Applies, my lord.
He'll be online, I think. You have come physically.
Yes, your lordship. Due
There
to
was a
some
prayer for
convenience. Yes. Due to some inconvenience with my technical issues with my laptop and camera. May I please, your lordship?
Anyway, yes, we have received this scan copy here.
Lordship,
Scan copy is already received.
scan copy received also.
Yes, you can sir.
Your lordships, this honorable court wide order dated 26/3/2026 was pleased to grant interim bail to
20?
petitioner. 26/3/2026.
Achha.
And therein in the said order, the prosecution side was asked to file an affidavit stating the stand that Lakhimpur police station is unnecessarily harassing the petitioner, whereas the case is pertaining to the Gulaghat police station, pending before the SDJM Bukaghat.
What was the direction?
The direction was in paragraph number 6.
Paragraph number 6.
Of the order, page number 2. May I read yours? In view of the fact that the name of the petitioner does not feature anywhere in the case records, he would not be having any apprehension of arrest, but in view of the specific averments that the police is trying to arrest him, which is supported by an affidavit, this court deems it fit to call upon the prosecution to submit an affidavit stating the stand of the investigating authority. The case has been charge sheeted, Your Lordship. I'm not the FIR named, neither in the charge sheet. Nothing has been possessed from me. I live in
You are
Lakhimpur.
now charge-sheeted accused.
I'm not named in the FIR, neither in the charge sheet. I have no connection with the case. I live in Lakhimpur. May I please, Your Lordship, give this honorable court a brief.
Charge-sheeted also.
I would like to give a brief of the facts of the case.
What is your name?
Charge sheet was filed, Your Lordship, on 25/9/2025.
CS 25/9.
But that was part charge sheet, Your Lordship. Pending the sanction of the prosecution for Section 25 of the Arms Act. May I, Your Lordship, for the sake of brevity, I would make the facts of the case
25/9/25. It was a part charge.
part charge sheet. FIR was lodged on 25/6/25. There was an incident in Gauhati in APBN army camp pertaining to blast of bomb, and some army officials got injured. Thereafter, police investigated the case, arrested total 8 numbers of accused persons. There is specifically mentioned in page 3 of my petition, Your Lordship, paragraph 4. Total 10 numbers are accused. Out of 10, 8 were charge sheeted, 2 were not charge sheeted. Now, the facts of the case is that I have come to know this from my sister-in-law that one of the accused, his name is Raju Das, number 6. After bail, he informed that my name was uttered by one of the co-accused pertaining to number 5, Uddhav Bonia. Thereafter, since August 2025, Lakhimpur Police Station, OC, is constantly coming to search me, raid me, or arrest me. Thereafter, Your Lordship, I have approached this honorable court in the month of January 2026. March 2026, I was granted interim bail with the instruction to be collected by the investigating agency that while Lakhimpur police is in search of me. So I'm not connected to the case, Your Lordship, no direct evidence. And moreover, Your Lordship, my wife was also picked up by the Lakhimpur police station, took to the police station, and a signature in a blank paper was conducted by the police. Now, that is not my concern, Your Lordship. The sections of this case are rigorous. 10 years, life imprisonment, death. All the punishments pertaining to the conspiracy, attempt to murder, explosive act, and if arms act is applicable. But I was not present in the place of occurrence, not FIR, neither charge sheeted, neither police, Gauhati police called me anytime, neither the court called me, neither the investigating agency informed the court to issue a summon as witness to me. Nothing has been done to me. So to the conclusion, my humble submission is that no formal accusation exists here, Your Lordship. Abuse of police power, and most importantly, the fulfillment of legal criteria, that is 482, reason to believe that you may be arrested. The physical search by the local police, that is Lakhimpur police station, is concrete proof that satisfies this judicial scrutiny, Your Lordship. So my interim prayer may most humbly be made absolute, Your Lordship.
Lordship.
At any conditions, Your Lordship.
Subsequently, on 28/04/2026, we have received 28/04/2026 from the OC Gauhati Police Station regarding the involvement of the present petitioner in Gauhati PSK 7125. And from the report, we have come to know that no such material found against him regarding the involvement of the present petitioner. The report is here, Lordship, can kindly take it. What would I report to the
Your Lordship, I have myself been to the Lakhimpur police station and police is very eager to catch him.
But
I really don't know why.
This you have received from Gauhati.
Lordship? Yes.
Gauhati.
Yes, yes.
Now he is pressing upon Lakhimpur PS.
Lordship, this
Yes,
is
ma'am.
Lakhimpur.
No, ma'am. The little confusion to this case is that the case is pertinent to Gauhati PS.
It is,
But Lakhimpur PS is in search of me.
it is in respect of Gauhati PS case number 71
Yes.
oblique 2025.
Gauhati PS case number 71.
71 oblique 2025. To
25.
that regard, I have got some instruction. May I peruse?
No, but is there any clarification in regards to, it is saying that the police from Lakhimpur is searching for it?
That part we do not know, Lordship, but so far as in connection with Bokakhat PS case is 71/25 is concerned, we have the report.
And in my petition, I've
From the
stated
OC concerned.
that the
And you
Lakhimpur
have
police,
filed your petition in connection with which case?
this particular
Bokakhat.
case, Bukakhat PS
Bokakhat.
71/25.
So
But
to that regard, we have a.
the Lakhimpur PS is searching me under the instructions of the Bokakhat PS, and thereafter this honorable
How
court.
can we know this?
That has been known to me by the accused persons who were arrested and on bail, Your Lordship.
That is not your case, so what to do? Bokakhat, Lakhimpur, there may be some other information with Lakhimpur.
Might be, Lordship.
But we at this stage we cannot say because Bokakhat has filed a report that against you there is no material found against you.
Indeed, Your Lordship.
So in that context, Bokakhat PS, which interim was there, we can be either, but maybe how can it may be absolute? It is not case against him.
No case is resisted.
So it will be
No, your
accordingly disposed.
It is disposed of. It
Lordship,
Yes.
Gurubang Singh Sibia, Your Lordship, it's a
No,
Supreme Court
yes.
judgment. Even if I'm not in the FIR, not registered, I can be granted.
In that context only you have granted interim, isn't it?
Indeed, Your Lordship.
Now there is no such case, nothing is there, nothing against you. So
kindly
what to do? We
accept.
cannot pass a blanket order for you that in every cases you will be,
No, Your Lordship,
for
I'm only
some
seeking an
reason-
order for this Bokakhat case, Your Lordship, not for any blanket order, Your
Kindly
Lordship.
peruse.
What
Kindly
Bokakhat
consider my
says?
case.
Bokakhat says that there is no case.
Kindly peruse, Lordship. I have.
Now, as per his submission, you want to make it absolute or what kind of order?
Lordship.
There's when there is no case at all, how can you make it absolute now?
No, Lordship cannot be.
Now he is saying in one hand, he is saying that it is the Bokakhat PS, the case is Bokakhat.
Yes.
Now on the other hand, he is saying that Lakhimpur is searching.
Police is searching for him.
Why Lakhimpur will search for you?
Yes.
Even if suppose Lakhimpur is searching for you, that maybe you have
Some other
maybe
case-
involved in some other case.
Respect.
I admit that point, Your Lordship. That is why my humble prayer seeking bail in Bokakhat PS, not in Lakhimpur. I may be an accused. I may be. Police may have found something that is not known to me even. But for this particular case, I'm seeking for a bail, Your Lordship.
Yes, you have already granted with interim. Yes,
Interim protection was there, Lordship.
Yes, Your Lordship.
it's already there.
It is
Yes,
there,
this
Your
is
Lordship.
saying for absolute. How can you make the absolute now?
Yes,
Question-
there is no such case against him.
Your Lordship, there are
Gurubakh-
plethora of Supreme
Yeah,
Court judgments, Your Lordship.
There, I know
Your
Gurubakh.
Lordship, this will set a precedent that once I have to be arrested, then I have to go to the jail, then I have to prove that I'm not an accused, I'm a.
No, we are not on that. We are not saying that. You are
accept
saying
it.
that your maybe apprehension was there. So without registering a case, what Gurubakh is saying, without even registering, say you are entitled for anticipatory.
Yes.
And that in that context, we are granted with the interim.
Yes.
Yes,
No,
my lord.
report was called for. There is no such material against you. There is nothing against you. So question of arresting you doesn't arise at all.
Yes.
So
not
we
at all.
cannot pass in every case as just a blanket order that you won't be able to arrest in this case and then subsequently there may be some reason.
Yes.
I don't know at this stage. At this stage, there is nothing against you, so no case is registered against you. Neither the charge sheet is against you. That much only.
I admit, lastly and most humbly, Lordship,
There is
give me
no
a chance,
such
I'll come with Supreme Court judgments. Give me a chance, Your Lordship, for the interest of justice. For the day, give me a chance, Your Lordship. I most humbly.
Please say appropriate venture, please go with it. A list before appropriate bench. When we are not taking this matter, you will listing before appropriate bench. When it can be listed? Tomorrow, day after tomorrow. Will be day after tomorrow, will be possible for you?
Sure.
Like a blanket order, you take.
18th, Your Lordship, 18th. 18th.
Okay. List before appropriate bench, so without being repeated upon 18th. Report received from the Bokakhat PS, we came to the party. Okay, it will be listed on 18th. before
Deeply
appropriate.
obliged.
37.
May I please,
Yes.
Your Lordship?
Hmm.
Lordship, 37 and 38 both are same city, Your Lordship.
Same
And,
thing,
and in both
City
the
receivers.
cases, we are in interim, Your Lordship, and our statements are recorded, Your Lordship.
Both 37 and 38.
37 and 38 both, Your Lordship.
Okay, yes, yes, Bora. We'll see.
Statements are recorded.
What were the case was actually registered against you? Under
Lordship.
which section?
Lordship, the FIR is at page number at item number 37. FIR is at page number 105, Your Lordship. Allegation under section 406, 420, 467.
Page number 37.
105, Your Lordship.
No. FIR is at page
105, Your
100.
105.
Okay. Yes.
All are family members, Your Lordship. And civil suit was pending, Your Lordship.
Oh,
This was the case.
acha. Basically, it is a land dispute.
Lordship. In item number 37, the petitioner was the performer defendant in 2 title suits.
Mostly you have submitted once.
Lordship, that was wherein the first FIR was not registered and the second FIR was registered.
Your FIR is continuing from 107 to 11.
105.
105 from 105 to
Your Lordship.
long FIR, no?
Long FIR is entire FIR speaks about the civil suit, Your Lordship.
117. Yes, more for
Lordship, otherwise they have appeared before the court. Okay, IO investigating officer, the statement has been recorded.
And government employee.
Thank you. Order had Mr. Alexei Hussein, the counsel for the petition. I also had MS Sechpora, the learned additional PP, agreeing with the object. This is an application, section students, connection with students, receipt, parents receipt. It is submitted by Mr. Hussein. Written order again was separated by that in person to the order of interim period respect. In one there are 8 numbers.
Lordship, in
Yes.
item number 38, Your Lordship.
38, there are
37 to the petitioner, the 38 of petitioner. So and so they have already appeared before that before the investigating officer and cooperated in the investigation. They're still ready and willing to extend their cooperation if they're granted with the privilege of prayers. In item number 37, it will be item number 38 or day. If order submitted, then from the contents of the FIR itself, it's seen that it is basically a civil dispute between the parties. But case has been lost, giving a criminal color to the civil dispute. Next, MS Bora, the learned additional PP, submitted that there are some informative materials against the present petitioners. But it is a fact that they have already appeared before the IO and cooperated in the investigation. Next, considering the submission made by learned counsel for both sides, materials in the case diagram. Other aspects of the case, this court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. In view of this, court is of opinion that the petitioners entitled for privilege of pre-arrest bail. Accordingly, the order of interim pre-arrest bail dated pass 11/5/2026 in item number 37 are in item number 38. Interim is on page 13/5 with the date of is hereby made absolute with same terms. Okay, you have made been absolute.
But
is 46.
May I please, Your Lordship? Page 12 is the FIR, Your Lord. By CDSM.
Yes, sir. Here we have received the case diagram.
Yes. Herein, Your Lordship, the suspected meat was recovered from the house of one Elias Ali, Your Lordship.
Where? Where is the FIR?
Page 12, Your Lordship.
Yes.
Herein the suspected meat was recovered from the house of one Ilyas Ali, Your Lordship. And thereafter he was apprehended. And in the FIR, two-person name is mentioned that regarding this, the name of the present petitioner and one Fazl Ali, their name is only mentioned herein, that they are also involved along with the business of the said Ilyas Ahmed, Your Lordship. But in fact, Your Lordship, the petitioner, he has no any business, and it is admitted fact that he purchased meat, Your Lordship, from one Ilyas Ali, Your Lordship. And the alias offense has been herein prevent Assam Cattle Preservation Act, Section 13, subsection 1, and Section 11, subsection 1 of Prevention of Cruelty to Animal Act, 1960, and Section 299 of BNS, Your Lordship.
So as per allegation, it was a public place or where from?
It was
How-
from the house of one Ilyas Ali, Your Lordship, it was recovered.
Yes, sir.
And the present and just annexer to, Your Lordship, some medical prescriptions I have annexed here with this petition. The petitioner, he sustained injuries, Your Lordship, and thereby he sustained fracture injury, Your Lordship. And presently he is under treatment, Your Lordship.
Lordship, during the raid and search operation, the investigating officer has recovered beef meat from the possession of what? Illa Sadi. So Illa Sadi has revealed the fact that the petitioner from whose possession the meat has been seized, along with his associates, including the present petitioners, they used to steal the cows and thereafter they slaughters, and thereafter they used to sell the meats for commercial purpose, Lordship. And to that regard, Lordship, around 30.83 cases of suspected to be beef meat has been recovered from the house of Ilyas Ahmed. And accordingly, Lordship, I have gone through the seizure list also. Admittedly, it is recovered from his possession. But from the statement of the independent witness as well as the co-accused, that is Ilyas Ahmed, the complicity of the present petitioner is reflected from their statements. I'm reading the statement of the accused, Ilyas Ahmed. মোৰ নাম ওপৰত দিয়া ধৰণে সত্য হয় আমাৰ গাঁৱৰ ৰচিদ আলী তাৰ কেইবাজনো ব্যক্তিলৈ দীৰ্ঘদিন ধৰি গোমাংসক ব্যৱসায় চলাই আহিছে ময়ো মাজে সময়ে ৰচিদ আলীক লগত লৈ এই কাম কৰোঁ আজি ইংৰাজী ৪ তাৰিখে পুৱা হঠাৎ পুলিচ আহি মোক মাংসসহ গ্ৰেপ্তাৰ কৰে বাকী কেইজন পলাই যায় and another independent witness he has been stated like this lordship মই খেতি-বাতি কাম কৰোঁ আমাৰ গাঁৱৰ ৰচিদ আলিয়ে বহুদিন ধৰি অবৈধভাৱে গোমাংস ব্যৱসায় চলাই আহিছে লগতে আন কেইবাজনো তেওঁৰ সহযোগী হিচাপে কাম কৰে আজি ইংৰাজী ৪ তাৰিখে পুৱা সময়ত গৰু চৰাই কৰে পুলিচ অহা দেখি ৰচিদ আলি আৰু আন কেইজনে দৌৰি পলাই যায় পিছত পুলিচে ইল্লাছ আহমেদৰ ঘৰ তালাচী কৰি গৰু মাংস পায় আৰু মাংসখিনি জব্দ কৰি তেওঁক আটক কৰি থানালৈ লৈ যায় ৰচিদ ৰাজিবুল Sahidul, Sejul, Gilhas, Sahidul, Anwar Hato, বহুদিন ধৰি এই ব্যৱসায় কৰি আহিছিল যদিও বৰ্তমান এই ব্যৱসায় তেওঁলোক নকৰে other persons regarding other persons lordship and lordship whether those suspected meat has been beef or not for that purpose lordship it is sent for FSL so that report is also awaited so we need the uploaded lordship at this stage. Lordship may go through the statements.
And by stealing those cows and then this
They used to slaughter them and used for commercial purpose. Lordship. Sales for commercial purpose. And there are about more than 30 lordship, 30.83 cases of meat suspected beef meat has been recovered. And independent witnesses also supported the case. Lordship. I'm objecting at this stage.
But my guess is that your lordship he just purchased the beef your lordship from one Ilyas Ali.
That I have admitted.
And so far the restriction, whatever provided in the Act, Your Lordship, regarding 5 kilometers away from the Shatro, like this, Your Mandir, temple, Your Lordship. And that area, Your Lordship, completely, there is no any, that restriction is not applicable to that particular area, Your Lordship. Whatever maybe, Your Lordship, the petitioner is ready to cooperate with the investigation, and presently his health condition is also
Whether
not
there
good.
is anything come on that, any witness to that regard that they used to steal those cows and all, and by slaughtering it used for commercial purpose?
Lordship, only that part is illegally. They used to sell those beef meat, Lordship.
So what your submission?
Lordship, I'm objecting in this case.
But herein, Your Lordship, he is ready to cooperate with the investigation, Your Lordship, and
Since it is prohibited,
I admit it, Your Lordship.
since it is prohibited, Lordship.
And his health condition is also not good, Your Lordship.
Cannot
I
be
have
ground for bail, Lordship.
No health condition, it's okay, it's very nice.
any condition, Your Lordship, he may be.
In from which area this was there any this temple sutras or
The
Hindu
Lordship,
dominated area?
that suspected beef meat has been sent for FSA.
No.
To ascertain whether
This
that-
area is simply the Muslim dominated area. Was
So
there
to
any
that
other?
particular point, Lordship, they have not given any findings, Lordship. To that regard, Lordship may give a direction.
In para 6 of my petition, I have.
Whether it is come within that parameter. Lordship. To that regard, your Lordship.
Okay. Heard Mr. A.M. Khan, the learned counsel for the petition, also heard MS S.H. Bora, the learned petitioner PP appearing on behalf of state respondent. The CD receipt, however, it is submitted by MS Bora that the FSL report is still awaited. Though it is suspected to be FSL report is still awaited for the deceased material as to whether it is a FSL report is still awaited. Further, on considering the submission of Mr. Khan, the learned counsel for the petitioner, it is also directed to the IO to give a detailed report as to whether the area from where the suspected beef meat was recovered is falls under any restricted area. Let the case diary be returned. We're calling for an updated one. Based on, yes, after vacation only.
After vacation.
In the
15?
15.
15.
In the meantime, Your Lordship, there is no any interim, Your Lordship, that may be.
Not the
considered,
state, Lordship.
Not-
Anticipatory bail, Lordship.
No,
Lordship, a copy of
15/7.
the.
No. If Your Lordship will not consider the interim, Your Lordship, then after vacation, it will be too long date.
It's
Your-
Vacation will
bail,
not have
Today
any
is
date because your
anticipatory
this
bail
is
that-
your anticipatory, na?
Yes,
It
yes.
is not
Entry,
under-
I am saying, Your Lordship, if Your
Interim is
Lordship
not
is not considering the interim, Your Lordship, then the date, Your Lordship, kindly before vacation.
Before
Your-
vacation. we don't
Otherwise,
have
Your Lordship,
date. We don't
today
have
is-
date. Asani date.
as a Secretary.
Your petitioner is not behind the bar. He is
No,
outside
behind the
enjoying.
bar, Your Lordship,
enjoying
I am
his-
apprehending, Your Lordship, and presently his health condition is not also good.
On the very
Good.
day.
I am therefore only.
Good. He was a simple injury on his
Let it
medical
be on
case.
14 July, no issues, Lordship.
No,
Or 13 July.
Lordship, I am humbly praying, Your Lordship, any date before vacation. Your Lordship.
11. 25. Okay, then 25/6.
Okay.
Lordship, a copy of the order may be furnished.
Copy of order may be furnished to the response state.
May I please, Your Lordship?
Yes, 12.
Lordship, I'm seeking an adjournment in this matter, my lord. My lord, my senior SG was is suffering from eye infection from last Saturday, my lord. So matter may be fixed on coming Friday.
You are for the respondent.
Yes, my lord, respondent number 1.
You are for the petitioner.
Yes,
You are ready for.
yes, I have no objection.
Before vacation, not possible.
Well, there's urgency to make.
Pardon?
But there is an
So maybe urgency may be there, but before vacation, not present. You are Mr.
H. Kakoti.
Mr. H. Kakoti, name is not here.
On behalf of Mr. Jesse Gumi.
H. Kakoti appearing on behalf of Mr. J.C. Gokul. And also heard, you are Mr. Saikyan.
B Saikya, madam.
B. Saikya appearing on behalf of Mr. M.S. Ajji Borwa and submitted and paid for an adjournment stating that M.S. Ajji Borwa, the Learned and Guest Council, is not keeping well. On the Mr. Kakoti, the Learned Council appearing for the petition, also raised no objection to that. Do you have any interim?
No.
Was there any interim?
No, no, ma'am.
So admission there. 13th of July. Immediately on the vacation.
Much
13th.
obliged.
Mr. Parsa, you are here, I think. I just
Yes, Malad. Otherwise, they have filed one additional affidavit also. Malad, I have several times tried to contact the department, Malad. But I have not received any instruction till date. SL Government Council, Malad. One last opportunity may be granted, Malad. I'll try, Malad. With the Malad.
I mean, you have filed an additional.
Additional affidavit.
We have already filed at the time of motion hearing. Before that, we have. It is not that we have filed it.
Alia definitely will take time, Malad, but
The last week also, yeah.
Yes, Malad. I have took time, Malad, but I have not received. Once last opportunity, Malad, they have already interim is there, Malad. Immediately after the vacation, Malad. If not, Malad, then maybe hard on the many materials available on record.
No, on the basis of that additional, you require some.
Malad, sometime to file some objection, Malad, but they have not provided the materials yet.
No, you want to file objection also.
Malad. If Malad, one last chance, Malad, if not Malad provided, then
Hard Mr. Admission, also hard Mr. K.K. Prasad, Ilan CDC for the respondent. It is submitted by Mr. Prasad that that in spite of several contact made with the department, he has not received any instructions to make the reply in regards to the additional affidavit filed by the petitioner. However, he submitted that one last chance may be given to the respondent side to file their written objection, if any. Considering this submission made by Learned Council for both sides, it is seen that one more chance is given to the respondent side to make their to file their written objection, if any, against the additional affidavit filed by the petitioners. Let the matter be accordingly listed on 13th of July, so and so. The enabling respondent side to file their written objection, if any. However, the endeavor shall be made to heard the matter and in the admission column on the next date of listing. Full stop, interim be continued, deleted.
Can it be 20 July, Malad? Immediately after
20.
I'll file.
20.
Next, please.
It's where here the other side is not there.
Not appeared, Lordship.
Not
appeared. Notice is served, but the other side is not appeared. Lordship, yesterday, so Lordship, the previous date, Lordship was ordered to bring the medical documents which was filed before the court below. I have filed an additional affidavit on 11/6 to bring the record on of the medical
medical documents and medical certificates in support of the ex parte vacation petition. Maybe not in record, Lordship.
Through an additional affidavit you have
Through an
filed?
additional affidavit.
That's you have submitted it on 11/6, na?
11/6.
11/6 note is there, but regarding your submission is not there. I mean, your additional affidavit.
Affidavit, Lordship.
That is not there, only the scan copy of the entire case record of so and so as all. That apart, the scan copy on the last occasion we have perused,
Lordship.
most probably not completed one,
Lordship.
which filed the petitioner praying
Lordship.
for vacation of the for the ex parte order accompanied with the annexures. That was not accompanied, and that this year which we call for is also not received. And that apart, your affidavit, additional affidavit is also not tagged with the record.
Lordship, maybe.
So yesterday you have filed, na?
Oh,
you have filed on 11/6.
11, Lordship.
But it's not there. 11/6 to P bar.
11/6, Lordship.
11/6 was a Thursday.
Thursday, Lordship.
Maybe due to some reason, I don't know. That apart is scan copy is also not received.
Lordship.
No.
Complete copy was not received, Lordship.
Okay, then I heard Mr. S.R.A. Nasir, the learned counsel for evaluation. From the office note dated 11/6/2026, it is seen that scan copy of the entire record, including the petition filed by the petitioner, praying for vacation of the ex parte order, accompanied with annexures, are not received by the concerned section till date. In view of this, let a reminder be issued to the concerned court for submission of the complete TCR and along with the relevant documents as asked for. Full stop. Further, it is submitted next paragraph. Further, it is submitted by Mr. Nasir that on 11/6/2026 itself, he filed an additional affidavit to bring the medical documents and the petition, etc., for vacation of the ex parte order. But that has not been tagged along with the case record. Full stop. In view of this, the registry is also hereby directed to tag the additional affidavit which has already been filed by the petitioner on or before next date of this. List the matter 21st of July.
21st of July.
Yes.
Lordship. Oh, Lordship.
In the meantime, it will come on the
Lordship. Deeply obliged.
17 and 18. Yes. One is criminal petition, one is criminal revision.
Yes, my lord. Criminal petition for stay of the NBW. Criminal petition filed by the petitioner for stay of the NBW.
Acha.
Recall of the NBW.
Acha.
And then the revision petition is against the judgment and appeal order passed by the passing NI Act case, my lord.
Acha.
Petitioner was convicted by the trial court, my lord, trial magistrate.
Yes.
Against that order, petitioner preferred an appeal. Appeal was dismissed. Then against the dismissed order,
This revision is filed.
criminal revision, my lord. Now, during pending of the criminal revision before this court, my lord, the learned trial magistrate has issued NBW against the petitioner. So that order has been challenged by way of a criminal petition, my lord. And during pending of the petition, my lord, both the body have amicably settled the matter. Fight an agreement. Already at the time of the agreement, some payment was made. And again, my lord, in between, my lord, a further amount was paid. And the next installment is due on, my lord, 18th of, my lord, just after 2 days, my lord. So at this instance, my lord, my prayer is, my lord, at least this matter be at least be adjourned already for the time being until, my lord, final payment is made by the petitioner. That can be done.
After 4 weeks, my lord.
After 4 weeks, my lord. And, my lord, the earlier, my lord, lordship passed an interim order, staying the NBW order, PNA order, that may continue, my lord.
criminal petition, criminal recollection. Heard Mr. M.A. Islam, the learned counsel for the petition, and also heard Mr. K.M. Hassan, the learned counsel, appearing for the respondent. Case was fixed for admission hearing, but it is submitted by jointly by both Islam and Mr. Hussein that the parties have arrived at a settlement, amicable settlement, and in pursuant to the settlement, an agreement was executed, and some amount of money has already been paid to the petitioner on the day of execution of the agreement, and thereafter also another amount was paid by the petitioner to the respondent side. After the 18, after, when your next due is, just say 18.
That I'll have to check, my lord. Lordship,
Next,
this matter may be fixed after 4 weeks.
Next week, na. Within next week, another another amount of money will be also
on 18, on 18, my lord. After 2 days, my lord.
on
After 3 days, my lord.
18/6, so and so another amount of money towards compromise, towards the settlement will be paid by the petition. In view of this, the learned counsel appearing for both the parties has submitted that matter may be adjourned today, and giving a chance for full payment to the side post. Considering this submission made by learned counsel for both sides, let the matter be listed. We are not giving any date. After 4 weeks, we'll do.
My lord, Lordship, after 4 weeks.
4 weeks, as on a date to be by the registrar. The parties are also directed to intimate the court in regards to the further development for the compromise.
My lord.
My lord.
May please, Lord.
Yes.
Step,
Why it is in order column?
a step has already been taken upon respondent number.
You have taken
respondent,
steps.
but it will awaited. Still, Lordship, I prayed for filing of additional affidavit 1, but petitioner was ill. So though additional affidavit was ready, not yet filed today.
Oh, you could not file today.
So on next date, I will file.
Heard Mr. B. Pukam, the learned counsel for the petitioner, also heard Mr. Sorry, MSFH Pula, the learned petitioner BP, appearing on the court side respondent. From the office note dated 10/6/2023, it is seen that the service is still awaited for the respondent number 2. At the same time, it is submitted by Mr. Pukon that due to illness of the petitioner, the additional affidavit would not be filed before the court. Considering the submission made by Mr. Pukon, that the matter be accordingly listed. 20/07 so and so. Post service for the respondent number 2 be awaited till. Okay.
Deeply obliged.
Appeal Lordship, my lord. My lord, this I for leave petition for appeal for admit for the appeal, my lord, under NI Act, my lord.
You are for the victim complainant.
Yes, my lord. There is a contradictory both, my lord, 3 PWD and 3 DWR. PWD says that we have issued the checks in the name of the complainant. Complainant says that I never issue this, I do not issue any check in favor of the appellant, my lord. So, but as per record, I have seen the complainant issue the checks in favor of the appellant, my lord. So, my lord, at this stage, my lord,
May I point out one thing? This
Complainant, you are the complainant.
is the complaint.
I am the complainant, my lord.
No, you are the complainant.
Yes.
Against the acquittal you have come, isn't it?
Against acquittal, yes.
Against acquittal you have come.
Yes, yes.
Yes.
So that is why the leave petition is required, madam.
No, no, yes, there's no doubt about it. No, complainant, you are the complainant, so you will definitely say that we issued the check.
Yeah.
Then
No,
what is the case?
no, its check is issued by the madam, the opposite party, madam. Because
Obviously, yes, by the
but
opposite party.
the opposite party says the complainant never, I never issue any check in favor of the appellant.
Complainant.
Madam.
Ah.
That is the case. And
That is the case.
and my lord, the three deposition, my lord, kindly see my lord, page my lord,
My lord,
26.
may I point out one thing? It is a case of 2024. In 25, the Honorable Supreme Court says the leave is not required because the complainant,
He is complaining.
he is a victim, leave is not required.
Yes.
But appeal, he can file appeal under section 372 before this section.
374, na?
70 before this session. This is a judgment. Let them peruse this and next 2-3 days, my lord, it may fix. May not maintainable, my lord. And following this.
No, see, maintainable is one part and maintainable
Maintainable is
the
another
question.
part, my
The
lord.
question is that leave is not required at all.
Leave is
so
not
we can dispose of the matter and can register the appeal.
Oh.
It's not maintainable. Question of maintainability is not there here.
Yes, yes.
The
Leave is
question
not.
is that leave is not required at all.
Leave is not.
So if it is not required at all, then we can register the case.
Register the appeal. Now,
Yes.
then appeal is maintainable, not that can be decided.
That is
That can be decided on the next.
Pardon?
That may be decided when appeal is come, my lord.
Just tell us the particular section 370.
378 surplus 4 they have filed.
No, they have filed, but the proper section is 370.
No.
No, under
It is this the Supreme Court judgment, it is 2025.
Yes, sir. Yeah.
Did you?
Yeah.
Type of things that happened. By the way, I'm not. Okay. Okay. By the way,
Service.
They may file a appeal under section 372 provision. That is the Supreme Court says. In following that judgment, by the Delhi High Court also says. In Jagadish Prasad versus Horiram Adawal.
Criminal leave petition. Mr. H. Mr. H. Then counsel for the petition. So Mr. N. How still done it. Counsel appeal for the respondent. This is an application filed under section 378(3) of CRPC seeking leave of this court to prepare an appeal against the order of against the judgment and order dated 9/5/2024 passed by the learned additional CGM or better, acquitting the respondent number 1 from the charges under section 130 of the NI Act, being NI case number 115 of the it is submitted by Mr. Ali without considering the entire facts and circumstances as well as the evidence on record. The learned trial court below and passed the order of acquittal, for which the present petition has been filed, seeking legal leave of the court to file an acquittal, file an appeal against the order of acquittal. Next para, Mr. Hogg, the learned counsel for the respondent, submitted in this regard that as the cases of under DNI and the appellant is a victim of the complaint of this case, there is no requirement of any leave in the section 378(3) as prayed for, and the victim has the right to file an appeal against the order of it under section 372 of CLPC. In that regard, he also submitted relied on a decision of Honorable Supreme Court reported in 2025 0 Supreme SC 941, and also relied on another judgment of the Delhi High Court passed in criminal appeal number 257 of it. Next para, hearing this submission made by learned counsel for both sides, it is seen that the present case is in regards to NI Act, wherein the respondent number 1 got the order of acquittal by the judgment and order dated 9/5/2024 passed by learned additional CGM Borpeta. However, as the petitioner, as the appellant being the applicant appellant being the victim of the complainant, there is no need of separate filing of separate leave application for instituting an appeal against acquittal as the proviso under section 370, as per proviso under section 372 CRPC. In view of this, the present leave petition is disposed of accordingly, and the connected appeal filed against the order of acquittal as stated above is hereby is no in view of this is the registry is hereby directed to register and number the appeal, connected appeal, which is filed against the order and judgment dated so and so. That's on this according to let me love Prana. That's such a place. With the above submission, the present petition stands disposed. We are not passing any order of maintainability. It is disposed of and leave is not required. Your registry is directed to register a case and numbered and register the appeal.
Yes,
the connected and will be listed in due course. I had to dispose. Even a leave petition to dispose.
Here in 43, your lordship, the service in respect of respondent number 4 is still awaited, your lordship.
Respondent number 4.
4, staff reporter, your lordship, of the concerned newspaper.
Under which process you have taken steps through special force,
Lordship,
special speed force?
Lordship. Your lordship may let us wait for your lordship the service, and if service is not complete also, he would probably not be prejudiced by the order of the honorable court, your lordship. The issue is purely a issue of law, your lordship. So your lordship may fix
Okay,
the matter
whatever,
after
but the-
vacation, your lordship.
Pardon?
Matter may be fixed after vacation, your lordship, on a date, your lordship. In the last week of July, your lordship.
So he is basically a staff reporter.
Staff reporter. His name is not there. That is how they have made him party in the complaint case, your lordship.
Simply Assamia Protidin.
Assamia Protidin.
Then how we will go?
Lordship, it's
In
very
the-
difficult because it was in the newspaper, it was given as staff reporter, Lordship. Even we could not trace the name of the person, Lordship.
So how can we expect that the
Lord-
service will be completed without being a name and all?
But in the newspaper, it was reflected as staff reporter without the name, Lordship.
But at the time of filing your complaint, you have not filed any name and all. You could not
No,
find.
no,
We
that
cannot
is
just-
that is how they have filed, and that is how we have put their names, your lordship.
In the newspaper, it
Because-
was reflected as staff.
I can understand because simply
Staff reporter, your lordship, who will, there are many staff
the
reporters.
There are many staff reporters for Assamia Protidin. So out of which, who collected that report or who was the person or the staff reporter that for that relevant news and all? So
Lordship, Assamia Protidin, Lordship, they will be able to trace the person because they will have record, Lordship, with who is the person concerned with that article, Lordship.
who will be able?
Madam, I have also made a party in that as an opposite party. I am appearing for the other accused persons, madam. One, two, and three, madam.
1, 2, and 3.
Three.
And you are for?
For respondent number 5,
Respondent
Lordship.
5. Acha. So only 4 we are awaiting for
Yes,
4.
We are waiting.
So is there any way out how to because name is not there?
As you have suggested, my lord, if he is not a material party to it, then we can proceed. Or if
We
you
are
want to
respondent
wait,
number
we can wait.
Lordship.
Because we can we can direct the registry also to track the concernment.
Absolutely.
But that will also
Same thing, my lord, as
Same
you have
thing
pointed
will
out,
be there
there are
because,
many staff
no
reporters.
purpose
Now,
will
who
serve.
is that particular staff reporter, not disclosed? So let us wait till vacation
Vacation.
and thereafter we can
The
proceed.
last week of July, your lordship.
Administered as board of Internet Senior Counsel assisted by
Do somewhere
P.
around.
assisted by Mr. P.D. Chaudhary, the counsel for the petition.
And
Also
please-
heard Mr. Jeff Kamal, the learned senior counsel,
Assisted.
assisted by
Lead both.
assisted by G. Kaushik for the respond number 1, 2, and 3. And MS R. Burwa. This time I can remember. You are R. Burwa, she is P. Burwa. R. Burwa for the respond number 5. Respond number 5. However, the service is still awaited for the respond number 4. But hearing the counsel for the petitioners and as well as the respondent, it is seen that the name of the respondent number 2 is not mentioned neither in the original complaint nor here in the petition. That may be the reason for that may be the reason, that may be the reason why the service is still awaited for the respond number. However, it may be awaited till next date of listing, and otherwise it can be listed for admission.
Without
Service
will have to be complete, then it will come.
Okay, then the opinion has to be there, na?
Lords.
Service be waited for next date of listing. In the meantime, both the parties are hereby asked to assist the court if any name can be name of the staff reporter can be identified. If the staff reporter can be identified. Yes. Mr. Body. 20. 29th.
31st, your lord.
31st of July. So what we have done, we will await for service, but the question will be there that we are asked if both these parties, if the staff reporter can anyhow be identified, then just let the court to know. Then we can do something, otherwise.
His version is that on the next date, we'll sort out that issue.
Yeah, that issue. Okay.
That is what he is suggesting, my lord. And
So
so
we'll
far I am
list it down.
concerned, it's purely a legal matter, my lord.
That's
It's
what
not
he
going to
also
impact
submitted.
anybody.
His presence may not be required also.
Yeah. Because no prejudice will be caused to anybody, because law will be interpreted. Like.
3157.
No, my lord,
Interim orders will continue.
Interim
another
orders be
petition
continued
is-
till next date of stay.
criminal petition has been tagged in wherein I am the petitioner now, my lord. Item
Yes, yes, in 44, na?
Yes.
44.
Yes, my lord. It's tagged in matter. In their matter, I was the OP, my lord. Now I am the petitioner in this
In
same very
44,
case.
you are the petitioner.
Yes. No, I have not.
Same order has set.
Cannot be same because I have not made staff the party.
Impugn order.
Impugn order is same, man. Sorry. But only sole responsibility.
So
is
let's respond.
Here the sole responsibility.
Sole,
Lordship.
sole. Because the complainant is the only party, madam. I am against the complainant, I filed it, madam.
So you are the sole responsible.
Lordship.
Yes.
It's separately made up by Mr. So. And also had MS Arborwa, the learned counsel for the sole responsible.
Zetkama assisted by P. Dev Chaudhary.
Here earlier, yes, his name has already been
I-
reflected. That's why I saw the same name.
No, in this case, we are heard first, then them, madam.
Yes, obviously.
Otherwise confusion, madam.
No, that's why I asked him to make a separate order.
Right.
Separate order. So both the matters will be listed on 31st.
No,
Otherwise,
that is
in your case, there is nothing. It
nothing.
can be listed
Nothing.
for admission.
Only it's because
Plus
tagged in.
tagging.
I'll have
Okay,
to be tagged.
31st.
Much obliged, madam. Right.
Yes, 47. One I is there.
I am alone.
Yes. What is the I for?
I am for considering our bail prayer, seeking direction for considering our bail prayer. By
No, it's a criminal petition.
in criminal petition, what happened, my lord? One FIR has been filed against me under section 376. Subsequently, charge sheet has been framed and cognizance was taken. I am arrested during the investigation. I was released on bail. Subsequently, I married with the victim girl, and I have now one child also. So we both came before this honorable court to quash the entire proceeding. That proceeding was stayed by this honorable court. But during the pendency of criminal petition, NBW has been issued against me, and I was arrested on the strength of NBW.
You are already arrested.
Arrested on the strength of NBW.
Acha.
Thereafter, proceeding has been stayed by this honorable court, and I filed a bail petition before the trial court. Trial court said that as the proceeding has been stayed, so bail petition will not entertain. So when therefore this IA.
To I bail petition is moved or what? To I continue.
Let's see page number 35, my lord.
In spite of my lord, IA, my lord, he can file a face bail petition BA because on the strength of NBW he has been arrested. Maybe my lord, on the basis of my lord, though my lord, interim order is there, maybe by mistake it was not entertained. But after all, on the basis of NBW he was arrested. So he may approach with a BA, my lord. And
now, by the way, by this application, interlocutory application, what you have prayed for?
I am praying for to seeking direction to the trial court to entertain our bail petition.
To entertain your bail application.
Lordship. In the trial court, I have filed a bail application. The trial court said that as a honorable High Court, stay the further proceedings. So you approach the High Court on the bail petition Thereafter, the bail petition, I have withdrawn the bail petition on not pressed.
Consideration মানে that can be মানে and
Only that much.
and for মানে deciding the মানে criminal petition as he shall in the charge sheet scan PCR will be necessary. That is not
That is called for.
a call for that is not yet come মানে as per accordingly I have not seen. So if মানে considering the IA, that direction may be given consider as per law they will consider.
Yes, Lord.
I to heard Mr. H. Ahmed, the learned counsel petition. Also heard Mr. A.K. Brasher, the learned petition PP, appearing on behalf of state respondent.
Stay.
This interlocutory ban relative or 528 it is not maintainable under 520. Simple interlocutory. I have dictated in that manner only. Because question of 528 is not there. Because no order has been passed by the learned trial court below and not entertaining your bail application because it is the case.
Order
case
was
is
not
there.
passed, yes.
No order was passed.
No.
This is an interlocutory application whereby the petitioner sought for a direction to the learned session judge to entertain the bail application of the present petitioner who got arrested in connection with the sessions case number 62/2022 on 25/03/2026. Is submitted by Mr. Ahmed that I'm also confused. I don't know.
He can come for against that order also he can come
Come for
Order is not there, na? No order is there. That is the problem. That's what he is filing this application under 528. 528 will not be here because no order is there. No order. No, he got arrested on this on the basis of the NBW because earlier NBW was issued against him. On that strength, he got arrested.
He didn't get any immediately was
And
if there is doing an order from the trial court, then how that IA will be implemented?
No, but he is behind the bar now. That is the
for behind the bar,
Seeking direction, absolute direction may be given. Direction can be given.
Without taking any order.
otherwise he can directly seek a bail petition like here before High Court. On the basis, on the strength of NBW, he has been arrested.
You can do this. You can seek a bail.
Immediately you will get bail.
Oh, you can seek a bail application. I mean bail. That will be better, I think, because the after the order
Pass on this court. Will go. It not as per.
Next day.
So and solicits. After hearing the both sides, this sound from the present interlocutory application is not applicable to the present form. And hence the petitioner is hereby directed to approach directed to file a directed either to approach the learned trial court below with a fresh application for bail or may approach this court with similar kind of prayer. With the above observation, the present highest. So we made a direction. Either you can approach the learned trial court below or you can approach this court with a similar prayer of bail. That will be considered. Okay. And now what is the criminal position stage of the criminal position?
In that case, my lord, notice was issued and trial court record was called for, but that was
You are already at.
Lordship,
amicus curiae happened.
Lordship, the stay order from this honorable court was of 6/5/2026.
Yes.
And the NBW was issued by the Sessions Court on 25/3/2026. It was prior to the stay order.
No, that's what. That's why it was pending, but execution was subsequent. I mean, execution stay was there, but execution was subsequent.
And Lordship, it perused page
35.
35 of which?
Of the IA.
I.
Remand the accused person to judicial custody till 7/4. The remand already 25/3 was arrested, my lord. Then here, then in the criminal petition, my lord, when the stay order was granted on 6/5, he make a wrong statement, my lord.
Oh.
My lord, I also will
Before-
believe you.
Ah.
Before staying the
Before
further
staying,
proceeding, he was arrested.
arrested, then he may be a direct.
Because this order for stay or whatever was filed on 6/5
6/5.
2026. But you got arrested on earlier only.
25/3.
25.
Kindly minute payroll, my lord, page 35.
Yes.
You got 25/3.
It's a wrong order.
No, but one question is there, Mr. Parashar. This petition was filed on 6
During
June
pendency of the
2026.
criminal petition, my lord.
During
he was
pendency of the
arrested.
criminal petition only, he got arrested.
That's
Not
true, Your
before
Lordship.
5/6, 6/5.
That's true, Your Lordship,
But-
but before getting the stay order, he was
At the time
arrested.
at the time of getting the stay order, he should.
He was behind the bar.
That may be, my lord, he should disclose before the court that he had
Ah.
already been arrested. It was not disclosed.
It was not disclosed. Anyway, we'll do one thing. We'll dispose of the, we have already disposed of the IA. He may approach with and this petition. We are concerned about the criminal petition. So stay is there only. But the question is, in spite of say he is behind the bar, that is the question.
During
This is I may be closed and he will file a case.
So completely on their fault. Yes.
Then he again, on that day, and it is a court. Then he's already been arrested. Then that order would not be passed.
Mm.
Because at that point, and that order was not brought before the honorable. That order was passed. So it was there.
Obviously on fault on their part only. Because it could have disclosed the fact that he is already behind the bar.
On the
So
Now that order has no meaning.
no meaning. Now stay is meaningless now. At present, because he already arrested. So though this stay is there, but stay is what to say. It's become complicated because he could have disclosed the fact and then the order of something was there, bail or whatever was there, and then the
Actually,
order
on
of
that
stay could be
day,
there.
on that day, I was not aware.
Aware of.
his error.
Maybe. Anyway, we have disposed the IA. Now, will there be any requirement for stay of the proceeding? Will there be any requirement? Because he has already.
Already there.
No, but there is one point. He may be behind the bar, but the further proceeding may again create another problem. So let it be stayed only intermediate. We'll see to it on the next day. Heard Mr. H. Ahmed to recommend counsel for the petition. Also heard Mr. K.K. Parashar, Delaney additional PP, appearing on behalf of state respondent and MST Parashar, Delaney Amicus, appearing for the respondent number 2. The scan copy of the TCI has not been received. Issue reminder. The registry will do the needful. List the matter accordingly. Yes, after vacation. 21/7. In the meantime, you file any application or what?
I am. I close.
Yes.
I close.
I is close. I is.
7 of July.
May I please, Your Lordship? This is again the
We are not going to hear.
Lordship.
So you are appearing for the appellant now. For the respondent, you are there, na? Each.
Not a big matter, small matter, but hardly take half an hour from my side. Maximum.
From your side.
I leave it to your Lordship.
I have just gone through the statements of the evidence of the PW and all this, my lord. And If he is pressing the, he is pressing the I.
No, this is for hearing. It has come.
Well, today, well, hearing
Your part is ready?
2025. Yes.
2 years already elapsed, Your Worship. 5 years conviction, Your Worship. Either way, Your Worship.
Sir, আগতে কেইদিনমান এতিয়াতো from October.
Total
8 months.
3 দিন আছে আৰু।
7 months something earlier. But 10 years. 10 years. 10 years, 23 days. 10 years, 23 days. No.
We are trying to accommodate this week, but this week most probably will be, next week will be a motion day.
Lords.
Already, only this hearing days, we have already 50 matters. So can we do one thing, the 14th July is a Tuesday at 2 p.m. If it is fixed at 2 p.m., then it will be heard. No issue on that.
Well,
then other matters will be adjourned and your matter will be taken at 2 p.m.
Lordship, can we make a try on 22nd, Your Lordship?
22nd of June.
June.
No, we are not
June,
this day
Monday.
because of this motion day week will be there. Many matters will come up there. 14 July is a Tuesday, so I thought that it may be accommodated on that day at 2 p.m. Because if I fix the time, then obviously the other matters will be adjourned and your matter will be taken at 2. Maybe at 2 or at best at 2:15 or 2:30 at best.
I leave it to your Lordship. In fact, the family of the client is putting pressure on us also. You know, that's the problem, Your Lordship.
Mr. S. Botako, the learned senior advocate, assisted by MSP Bora, and counsel for the appellant here, and also heard Mr. K.K. Parashar, the learned additional PP, appearing for the respondent, state respondent, and MS. You are MS? Appearing on behalf of Mr. B.D. Kwon. B.D. Kwon, the learned senior advocate. Matter is okay. Just go to you. 14 July at 2 p.m.